48 and 49.
For reasons mentioned in the order, the petitioners are allowed to go on bail of rupees 2 lakh each with 2 sureties of like amount.
Deeply obliged.
Your Lordship's due permission, I beg for listing of a bail application, Lordship, that was filed yesterday and to be mentioned for tomorrow in the motion column. He is not a FIR accused, 37 days in custody plus murder is seriously ill. So kindly, Lordship, I may be allowed for listing of the matter tomorrow. Lordship.
Okay.
May I please, Your Lordship? My lord, this is a regular bail application filed on 6th of November, my lord. So, my lord, may I pray for listing tomorrow?
Okay. Okay.
Okay.
May I please, Lordship? I beg to mention for listing of an anticipated bail application on Friday, Lordship.
When have you filed?
Lordship on 10th of November. Lordship.
Okay.
Highly obliged.
Lordship, item 28, I filed an additional affidavit. This is not in record. Lordship, I may call
Call
for-
for the record.
May I please, Your Lordship, I beg to mention for listing one anticipatory bail application.
When have you filed?
Lordship, filed on 11/11, Lordship, in hearing column, Lordship. Yesterday it was listed, but due to paucity of time, it was left over, Lordship.
When do you want?
Friday, Lordship,
Okay.
deeply obliged.
May I please, Your Honor? My lord, I beg to mention for listing of a criminal petition, my lord. This matter,
Next week.
my lord, next date is Monday, my lord. Warrant,
When have you filed?
my lord, 6/11, my lord.
Okay, on Friday.
Most obliged.
May I please, Your Lordship? Lordship, I beg to mention on criminal revision petition, it came up for motion on 23rd and it was listed for motion only after 1 week. So 1 week have already passed. I'm praying it for Friday, Lordship.
Okay.
Therefore, listing admission matter of a criminal petition next week enable.
Next week.
Lordship, I beg to mention for listing a criminal petition, Lordship, is for withdrawal, Lordship.
Okay.
Obliged. Please, Your Lordship, I beg to mention item 25 for adjournment.
What is the, on what ground?
Lordship, conducting council has some personal difficulties.
Lordship, I have an objection in that matter. Lordship. The last provision, Lordship, it was hard on length and it was only pending for the response. Lordship. A legal question was raised regarding the maintainability of the bail application. On that day also, Lordship, I had paid for
Yes.
process.
Please, Lordship, adjourn for the day.
What difficulty? Rejected. Prayer is rejected. Yes.
Please, Lordship, I beg to mention item number 30, Lordship. Lordship, as per my instruction, searching had already been laid, Lordship. So we will approach to the trial court. 30,
You are withdrawing this
Lordship,
item number?
30.
Heard Miss, what is your name?
N.
N. Borwa, learned counsel for the petitioner, who submits that as since the charge sheet has been laid, the petitioner is inclined to approach the trial court for seeking regular bail. Hence, prays for allowing the petitioner to withdraw the instant bail application. The prayer is allowed. This bail application is dismissed on withdrawal.
Wait, please, Your Lordship, I beg to mention item number 16, Lordship. Can the matter adjourn for 1 week, Lordship? My senior PKR has some personal difficulties, Lordship.
What is your name?
K. Ghosh.
Heard Ms. J. Ghosh, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner. Considering the ground, the prayer is allowed. Let this matter be listed in the next week on a date to be fixed by registry.
May I please, Your Lordship? I beg to mention a criminal petition for withdraw, Your Lordship, for list.
Tomorrow.
May I please, Your Lordship, I beg to mention a criminal petition for admission, Your Lordship. Because in this case, in spite of the interim stay, the NBW has been issued, Your Lordship.
When is the date, next date?
Your Lordship.
When do you want?
Friday,
Okay.
oblige, Your Lordship. It was listing of a BA, your lordship, is behind the bar since the month. of
When have
March.
you filed?
It was filed on 27, LCR was called for, and the LCR is also received on 7th of this month. So it may be kindly taken up.
When the next date was fixed?
When next date is not fixed, it was fixed for LCR. and the
Tuesday.
LCR is received
Tuesday.
on Friday, your lordship.
Friday, it may not reach if we go on listing all the matters on Tuesday.
On Monday, your lordship.
Okay, Monday.
PPG Lordship. My lord, I pray for listing of a criminal revision petition for others claim Lordship. I pray for next week Lordship
Next week.
on Tuesday Lordship.
Okay.
Deeply obliged.
May I please, Your Lordship, my prayer is for listing a criminal petition, Lordship. Lordship, the matter was last listed on May, Lordship. After that matter is not listed. So our urgency was similar matter already disposed of, Lordship. So kindly matter may be taken on next week, any date, Lordship.
Okay,
There's to mention for listing of a DA, Lordship, for withdrawal.
tomorrow.
Master place. May I please, Your Lordship, I beg to mention two criminal petition matter.
For listing,
Yes, Lord.
for listing
Yes, Lord.
next week.
Kindly fix a date, Your Lordship.
Next week on a date to be fixed by registry.
May it please, your lordship. My lord, one application is fixed on 14 from the same FIR. I am thinking of listing a matter for motion on the day, lordship.
When have you filed?
I filed on 10th, lordship.
Okay,
Obliged.
It is your lordship. Lordship, I beg to mention for listing a bail application for motion for tomorrow.
when have you filed?
Lordship, today, lordship.
No, it will be listed in its due course.
So the notice will go. for
No,
Friday, lordship.
no,
Obliged, your lordship.
no mentioning just by filing in the filing section and coming to mention. You have to wait for the normal time which it takes for mentioning.
Obliged, your lordship.
Lordship, may I beg to mention criminal petition, two criminal petition and one original petition. Lordship, it was last listed on May and after that it has not been listed.
Next week,
Lordship, 18,
no fixed date.
may I please the Lordship? For listing of a criminal appeal, Your Lordship, on 14.
No, 14th may not be possible.
Yes, Your Lordship, he has already served his punishment for 1 year, Your Lordship, 5 years imprisonment was.
Next week.
A date may be.
And date may be fixed by registry.
May it please, Lordship. Lordship, we have filed a BA, the date of filing 11/11/2025. That may be.
Wait for normal listing. No mentioning in such cases.
May I please, mention? Criminal petition, my lord, motion matter.
When have you filed?
I filed, it was last posted in this code, but due to paucity of time, it could not have been taken. It was deferred. May it be listed tomorrow, my lord.
Okay,
Okay.
I had a pair, but lordship has not granted an idea.
if you have filed yesterday,
No,
then
lordship,
wait for,
today, the order filing, urgency is that entire 6 family member has been robbed in the FIR.
it will be listed automatically within
As the
2
lordship
days.
has not granted the Hara council, so I will not pay.
Okay.
Obliged, lordship.
Item 50 and 51 for withdrawal.
Lordship, item 50 may be withdrawn. Though both of the item came from same FIR, but this is different here.
Item number 50,
50.
heard Mr.
Yes, should be.
A.S. Chaudhary, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant bail application. Instant criminal petition, the prayer is allowed. This criminal petition is dismissed on withdrawal. And 51?
Sure.
51 also. Same order. Council's name Jay Ghosh. Jay Ghosh, Bakia ke order.
Right, Lordship.
Also, item number 1.
Yes. From this side.
May please, Your Lordship. So this is a criminal revision.
Why have you not engaged a lawyer?
Sir, actually, When I, last time, for this case only, I have engaged the lawyer, legal ad. But that I am not satisfied with their working and the things. I didn't get any knowledge what is going on in the proceedings and all properly.
Okay. We are issuing notice and appointing an amicus curiae. Heard Miss Neha Agarwal, the petitioner appearing in person. This application has been filed by the petitioner impugning the order dated order dated 13/8/2025, passed by learned Special Judicial Magistrate, First Class, Kamrup Metro, whereby the complaint filed by the present petitioner was dismissed by the trial court on the ground that no sufficient grounds to exist for proceeding against the accused. Stop. After hearing the petitioner in person and after going through the records, this court intends to examine the issue involved in this case. Hence, issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent by speed post within 7 days of the date of this order, as well as by usual mode within the same period of time, returnable on 9th of December 2025. Considering the issue involved in this case, this court is inclined to appoint Mr. Sarfaraz Nawaz as the amicus curiae to assist this court. List accordingly. You take steps. Go through the order.
I thank you.
Thank you.
Yeah, please, Your Lordship. Statutory revision, Your Lordship. The interim order and judgment is on page number, from page number 228 to 256, Your Honor, whereby the petitioner was directed to pay a monthly maintenance of ₹7,000 to the petitioner and ₹5,000 to the minor daughter from the date of application. Your Lordship, before going to the merits of the case, Your Honor, I would like to bring certain facts before this honorable court about whether this interim order and judgment have some merits or not. Your Lordship.
Okay, we are issuing notice. Who is the opposite party? Your wife?
The opposite party is not the wife, Your Honor. Actually, Your Honor, in this, Your Lordship, there was no social or any court marriage in the party.
Who is she? She is a stranger.
Was the resident of the locality where the petitioner was also residing. The matter was pending before the Honorable Principal Judge, Family Court number 1 since 11 years. And the final judgment was passed on 28/8/2025. Before that, Your Honor, we have filed certain petition before the trial court below.
This is a final order.
This is the final order.
Okay, we are issuing notice. Heard, Mr. What is your name?
R. Khan.
R. Khan, learned counsel for the petitioner. This application under section 438 of BNSS, read with section 19 within bracket 4 of the Family Court Act 1984. 1984. Has been filed by the petitioner Mohammad Jahid Hussain, impugning the judgment and order dated 28/8/2025, passed by the Court of Learned Principal Judge, Family Court number 1, Kamrup Metro, in FC within bracket criminal case number 327 of 2014. By directing the present petitioner to pay a monthly maintenance allowance of rupees 12,000. Stop. To the respondent and her children. Issue notice to the respondent.
Lordship, I'm trying for the interim.
No interim at this stage.
The sort of execution, the execution sitting has already been registered by the honorable. Trial
What
Court.
is the number?
The number, we have just got the message, but it has been registered.
No.
I will apply to the court. that
On the next day.
this interim is necessary. So similar- The thing is that I have already been acquitted from all the charges, that whether the marriage has been solemnized or not, that judgment is already been
No,
included.
we'll examine your plea, but no interim at this stage. Let the other side appear and place her story.
Till the notice.
Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent by speed post within. When is the date fixed in execution case?
No, we just got the message.
No, then let the,
Take confirmation from the. client.
no. Why are you
No,
not,
see, just got the message. but,
you are not prepared for interim by by filing a revision petition, merely asking for interim. Do you think that Cal-
Applies to the court that why the interim has been necessary in this case, really, because
within 7 days from the date of this order, returnable, we are fixing a short date. Returnable on 2nd of December. 2nd of December. Let the records of the let the scan copy of the records of FC criminal case number 327/2014 be called for from the trial court. List accordingly.
hold on.
May I please? This application is filed against the order of Jimma has been rejected by this trial court minor. On the ground
Jimma?
that your lordship file, the fact of the case is that your lordship, just coming to the fact, well, there was a vehicle bearing number, your lordship may kindly come to page 21 is the FIR. FIR. They have intercepted one vehicle, my lord, that is AS23DC 0901, my lord. The where petitioner was the registered owner, my lord. It was driven by his driver, and some heroin was recovered, my lord, from the custody of these accused persons, my lord. There were 4 accused persons, and total heroin that has been seized is around,
Heroin was recovered from your vehicle.
not vehicle, from the personal custody. Means only a small quantity, 0.55 grams. Your lordship may kindly come to see that page 26. Page
Okay.
net weights, my lord. Total is 0.11. 0.11 total it comes to. So total weight is 0.54 mile. 5 milligram is the small quantity. Is below small quantity because they are addicts, my lord. For personal use, it was taken, my lord. So I was a registered owner. I had a contract with ONGC, my lord, for giving this as a contract was signed between the parties, my lord, by the ONGC and the petitioner, my lord. But without my knowledge, they have went for a ride, my lord, and it was used for personal use. Now, I paid for Jimma of the vehicle on 27.
What is your relationship with the accused persons?
Accused by who is one of my driver,
Okay.
and he's a resident of Jorhat.
Where is the rejection order?
Rejection order, your lordship will find at 12,
Page 51.
page 51, my lord.
Why it was rejected?
Rejected, my lord, your lordship will find that on the ground that there is a possibility of confiscation of the vehicle, my lord. But so far, that your lordship has seen that there was a report submitted, page 52, my lord. Report submitted by OC, Titapur PS, that Tata Yodha, cabin maker so-and-so, was his connection with so-and-so. So case was charged by CS number so-and-so. As far as resident certificate, owner of the vehicle is Techno Elect, that is the partnership firm. ownership firm proprietor is Hemanta Sharma.
You are Hemanta Sharma.
I am Hemanta Sharma. It is further reported that said vehicle was seized from the possession of a driver and co-accused and vehicle was involved in trade. That is a wrong, not trade, my lord, there is a personal use. I have perused the report. In the said report, I raised objection to the prayer of Jimma stating that the vehicle is liable to be confiscated and also sought permission for such confiscation. And what transpires from both the reports that said vehicle is used for trading NDPS Act. I like to mention that section 60 of the NDPS Act, a conveyance along with the illicit drugs shall be liable to be confiscated under section, and section 3 of the Act provides for procedure making confiscation. Section 52A provides for disposal of seized conveyance such officer in such manner as prescribed by government notification. But your lordship will kindly come to section 60, my lord. Section 60 is very clear, my lord.
After NDPS now.
Yes, section 60 states
Upon conviction,
liability of illicit drug substance, articles and conveyance to confiscation. Section 60, subsection 3, my lord, says any animal conveyance using or carrying any narcotic drug and subsequent substance, an article liable to be confiscation, and so, unless the owner of the animal so and so. Because that vehicle was not used for carrying. Because the item is very small quantity, 0.55 total. 0.11, 0.21, 0.21, and they were found inside the pack, personal for consumption. It was used, and the vehicle was not used for carrying these articles. They was a personal property, man. So, and it is small, falls under the much below the small quantity. Is for personal use. So, my humble submission, my lord, it cannot be offense. It cannot be said that this vehicle was used for carrying any narcotic drugs. And I'm being, there was no case of the prosecution that I conspired with, I was never made an accused in this case, man. And it in a case that I also is party to the conspiracy or something that is there is no evidence to that effect also. So I was not made an accused. So it is not a case for confiscation. As of today also, no notice for confiscation was issued to me, man, by the appropriate authority. Because the quantity is much below the small quantity. And it was found inside the pants wearing apparels of these accused persons on being searched.
yes, Mr. Bhatta.
Yes, my lord, as per the submission of my lord, that petitioner is not an accused in the said case, my lord. Anyway, my lord, if he is not an accused and without going into the, my lord, confiscation proceedings, my lord, if the petitioner is an accused as per the Supreme Court decision in Biswajit Dey versus State of Assam, then he is not entitled for, my lord, getting custody of the vehicle in NDPS cases.
Which decision?
Biswajit Dey versus State of Assam.
If he is an accused,
If he is an accused, my lord.
that is not applicable in the fact.
Reported in 2025 3 SCC, my lord. But here in this case, regarding that confiscation proceeding, I will have to get a report from the IO, my lord, regarding the present stage of that proceeding.
Because first of all, they have to satisfy the court that this vehicle was used for.
No, should we call for a report from the IO whether
Yes.
confiscation procedure?
Yes, that can be done. my lord.
We will fix a short date.
Yes, sir. Because since the quantity is very less, and
Yes.
it was for personal,
Otherwise, it appears that you are entitled to get.
Yes.
yes, because it was personal, content, it was found inside their pants, wearing apparel.
Or should we dispose it off?
Otherwise, my lord, that application, whether, my lord, without his knowledge, that vehicle, that, my lord, my
That will come later on when their
Later on,
notice has been
yes,
issued under confiscation. But as on today, I was no notice has been issued, nothing has been initiated as on today.
Okay, we are fixing a very short date.
Yes,
Heard Mr. P. Kotoki, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned additional public prosecutor. This application under section 438/442 of BNSS has been filed by the petitioner Shri Hemanta Sharma, who is aggrieved with the order dated 14/10/2025 passed by learned Special Judge Jorhat in connection with Titabar PS case number 128/2025, whereby the prayer for seeking Jimma of the vehicle seized in that case was rejected by the state court. Learned counsel for the petitioner has submitted that the petitioner is the owner of the said vehicle and it was used by the at the relevant point of time by the driver of the vehicle along with some other associates. He submits that small quantity of contraband were recovered from the personal possession of the occupants of the vehicle. And the vehicle was not used for carrying the contraband. He further submits that the petitioner had no knowledge about use of his vehicle in the offense alleged in the case. And hence, the trial court has erred in rejecting the prayer for Jimma filed by the present petitioner. On the other hand, learned counsel for the petitioner, learned additional public prosecutor submits that since any vehicle found associated in an offense whereby allegations have been made of carrying the contraband is subject to confiscation. Hence, he seeks some time to get information from the investigating officer as to whether any confiscation proceeding has been initiated or not. The prayer is allowed. Let a report be called for from the investigating officer
Yes.
of
Titawar PS case. number.
Titawar PS case number 128/2025 as to whether any confiscation proceeding has been initiated in respect of the seized vehicle or not. Let this case be listed in the next week. Date at the no next listed on 21st of November.
Lordship, there is a 601 days of delay while preparing this criminal legal petition.
Delay condonation application is there.
Lordship, there is Lordship. It means the Lordship notice may go.
Where is the interlocutory application is there?
There.
What is the issue?
The interim judgment of the non-met court below Lordship. Lordship, our maintenance has been disallowed by the court below.
Okay, we'll issue notice. Heard, Mr. What is your name?
AK Kanu.
A.K. Khan, learned counsel for the
Kanu.
A.K. Khan,
Kanu, Lordship.
A.K. sorry, A.K. Kanu, learned counsel for the petitioner. This interlocutory application has been filed by the applicant for condoning the delay of 590 days. How many days delay? 590 days in filing the connected criminal revision petition, whereby the petitioner has impugned the order dated 16/11/2023 passed by the Principal Judge Family Court, Kachar, in FC criminal case number 1/2019. Stop. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 12th of December, list accordingly.
Item 5. My lord, after some time.
Okay, okay, after something.
Item 6.
May I please, Your Lord?
Yes,
That we have filed this petition, my lord, for quashing of the proceeding, my lord, initiated against the in-laws, my lord. And where the in-laws, my lord, page 17 is the complaint petition,
what proceeding?
my lord, domestic violence proceeding, my lord. We have been made accused number 2, 3, and 4. One is husband. And in the complaint petition, my lord, all the allegations, my lord, against the husband and against us, my lord, that we have instigated the husband. Only instigation is against us. And lordship kindly see page 26. She has summarized, my lord, in paragraph 18.
Any relief has been sought for against?
Relief also, my lord, against husband. Relief, my lord, page. Relief, my lord, page 31. Relief against, my lord, the in-laws, my lord, protection, because she wants protection, but in her petition, my lord, she is saying that she has been living in her parents' house.
When is the next date fixed?
10, 12, my lord.
Heard, Mr.
Well, in the meantime, well, interim has been granted for next date for payment.
Heard. Payment by husband only.
Payment by husband.
Heard, Mr. R. Ali, learned counsel for the petitioner. This application under section 528 of BNSS has been filed by the petitioner praying for quashing of the DV case number 228/2024. Pending before the Court of Learned Special Judicial Magistrate First Class Kamru. You are quashing, you're seeking quashing against the petitioner or against everyone?
No, my lord, only petitioners, my lord. We are in-laws, my lord. Not against husband. Husband is not before law.
Qua the present petitioners. Stop. No, I have gone through the criminal petition and heard learned counsel for the petitioner. Issue notice to the respondents. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 8th of December 2025. Let also the scanned copy of the DV case, records of DV case number 228/2024 be called for list accordingly.
Yeah, in the meantime, my lord,
Next item.
Item 7.
Nothing has been, no interim relief.
we have to appear there, my lord, every day, my lord.
This date is before the next date of appearance.
There is a part 28 application on the BNS for quashing the proceedings initiated by the SDGM Dibrugarh in a DB proceeding lordship. the entire DP proceeding is full of flaws and it is abuse of the process of law. What happens, Lordship, the petitioner petitioner works in the US. Presently, he is in Bangalore in India. He has left his US thing, came back to India, requested the company to put him in India because of all the things happens in his family, Lordship. And then he comes and files a divorce petition. Getting the divorce, receiving of the notice of the divorce petition, the respondent comes back from US. Hastily, she files this domestic violence petition, my lord. There are other also there. She also files maintenance under the CRPC. And then, Lordship, I can show the flaws in her, as apparent on the face of her petition, Lordship. She states some very wrong things, Lordship.
No, on what grounds
Yes, she
you are
says,
seeking quashing?
Lordship, accused of the process of law, Lordship. I'll point out the things, Lordship. Lordship will come to para 41,
When is the next date fixed?
to December, but she has already left India. That is why I would just want to satisfy Lordship that Lordship may stay the proceeding, Lordship.
No,
After
we-
filing,
we'll issue notice fixing the matter before 22 December. We'll issue notice. Heard.
submitted, Lordship. There are some typical error and the WhatsApp message which I have put here has one particular original one is missing, so I have to annex it here. I already
Then,
stated.
then you rectify the
Yes.
matter, then we will take it up after rectification.
I will-
Tomorrow, we'll take it up tomorrow, Monday, okay. Heard Miss S. Parveen, learned counsel for the petitioner, who prays for allowing the petitioner to rectify some typographical mistakes which have crept in the criminal petition. You rectify,
65B initially, it was at 63 now under the New Evidence Act.
and you want to file additional affidavit.
I may be allowed to put here my section 63, I suppose, under the.
You file a amended criminal petition making after all corrections.
Yes, that typical one, I can remove it with eraser, or I can change the page, Lordship. Only the last lines of a particular page.
She also files praise for allowing the petitioner to file an additional affidavit to bring on record certain facts which are relevant for consideration of this criminal petition. Prayer is allowed. The petitioner may file rectified corrected copy of the relevant pages of the criminal petition before the next date. Let this matter be listed again on Monday. Monday is 17th November.
Item 8.
Please, Your Lordship. This petition is against disallowing me to cross-examine the prosecution witnesses, my lord, after alteration charge. And my lord, disallowing my counsel to cross-examine those 3 witnesses who were directed to be examined by me, by the accused himself. If my lord comes to the order altering charge, my lord, at page, my lord, at page 40. Charge sheet was laid under 354C, my lord. Initially, thereafter 354A had been added. Page 40, my lord. My previous counsel died, and that is why, my lord, on that day, on 17th of January, my lord, he was, I was not represented by a counsel, so I requested someone who was there to represent me on that day. If my lord comes to page 40, my lord, there were 2 witnesses who were present. Seen petition number 136, filed on behalf of the accused, stating that his erstwhile engaged counsel, Sri Orup Kolita, had expired, and today newly engaged counsel, so had filed Wakalatnama and prayed for some adjournment, stating that the learned counsel is appearing for the first time today. Time is required to prepare for the defense of the accused. Having considered submissions, I am allowing the prayer subject to a payment of cost of ₹500 to be paid by the accused to each of the PWs present today and on the next date. PWs present today are directed to appear on the next date and further process not required. My lord may come to the next para, my lord. next page, sorry. Involving the last line, I am of the opinion that offense under section 354A of the IPC needs to be added in this case for proper adjudication. Accordingly, charge under 354A of the IPC is framed and particulars read over to and explained to the accused, to which he has pleaded not guilty. Charge under 354A of IPC is added to already existing charge under 354C IPC. The defense shall be at liberty to cross-examine the PWs examined already fresh. But this is all right, madam. There were 3 witnesses who were who had already been examined, PW 1, 2, and 3. So liberty was given to me to cross-examine them afresh on the added charge. My lord, thereafter, my lord, on the next day, the next day, which was fixed, my lord, was a holiday. So the matter came up, my lord, on 26th of July at page 44, my lord.
Yes.
My lord may directly come to page 46. The second last paragraph, my lord, it is also apparent, lordship finds.
Yes.
It is also apparent that the accused is deliberately employing dilatory tactics to harass the female.
No, why this order was
My
passed?
lord, on that day, my lord, may I read the entire order that quickly?
No, you tell me
My
the
lord.
gist.
My lord, my previous counsel, Orup Kolita, had died, lordship had seen from the earlier order. My lord, a newly engaged counsel whom I found on the court on that day, my lord, I had requested him to appear. But my lord, there was some communication gap between the counsel and me, and therefore he was not willing to proceed with the case. I had requested him to give an NOC, he did not give. So this is recorded in this order that till I was given time till 2 p.m. on that day to produce an NOC. My lord, without NOC, no other counsel was willing to take over the matter. So therefore, my lord, the court was of the opinion that I was employing delaying tactics to delay the matter. Another counsel whom I approached, my lord, he appeared before the court and said that because of the absence of NOC, he is not able to appear. Because that would be a professional misconduct on his part. And that is why he did not.
Why?
My lord, without NOC, my lord.
Is there any requirement?
Yes, my lord. Under the Bar Council rules, it's required, my lord. Without NOC,
A client cannot engage more than one set of counsel.
my lord, if a previous counsel is on record, my lord, without NOC from the previous counsel, any other counsel cannot take.
Where is that?
Or in the Bar Council rules. Otherwise, it's a case of misconduct. In fact, there are proceedings on that. We have initiated proceedings from the Bar Council side, my lord.
Okay, some other day you let me know about the rules.
Of course. Afternoon, my lord.
Okay,
is,
okay.
The Bar Council required. It is required. It is there in the Bar Council.
Okay,
Anyway,
then what happened?
my lord, because of the refusal to give NOC, the other counsel also could not appear. My lord, I was directed to cross-examine the PWs who were present on that day, that is PW 2, 3, my lord, 4, 5, and 6. And accordingly, I was compelled to cross-examine them, lordship, but in the order it is reflected otherwise, my lord. In the order it's reflected that I volunteered to cross-examine, which is, my lord, not correct. My lord,
The accused himself.
yes, my lord, accused himself.
Okay.
My lord, page 46, the second last paragraph. Such conduct of the accused is not at all acceptable. And at 11:30 p.m., I had given time till 2:30 p.m. to the accused to make necessary arrangement to conduct a cross-examination of the PWs and had been waiting patiently since 10:30 a.m. At 2:30 a.m., the accused appeared before me and prayed that the case be adjourned today. As already stated above, the ground for adjournment is not at all acceptable and hence prayer for adjournment is rejected. As no counsel appeared for the accused at 2:30 p.m., the accused had volunteered to cross-examine the PWs today and the same is allowed. Although this is in fact not correct, so I'm not challenging this, and I was compelled to cross-examine. PW4, Seema Pandey, PW5, Bhagyalakshmi Deka, and PW6, Kakoli Bujarbura are examined, crossed, and discharged. My lord, this had happened. I had earlier approached lordships by way of another criminal petition, but since there was no petition filed in the court below, my lord, I had withdrawn that earlier criminal petition. My lord, I had thereafter filed a petition, my lord, at page 50.
Yes,
my lord, may come to the prayer portion at page 53.
yes.
The prayer, it is therefore most specifically prayed that this honorable court may graciously be pleased to A, recall prosecution witnesses PW 4, 5, and PW 6 for re-cross examination through defense counsel, and B, recall prosecution witnesses PW 1, 2, and 3 for cross examination in the light of the newly added charge under section 354 AIPC. This has not been allowed, and therefore I am before lordships. The impugned order, my lord, at page 56.
Yes,
The third paragraph, my lord, learned counsel for the accused has filed petition number so and so, while praying for recalling the prosecution.
who are the witnesses?
My lord, 1, 2, and 3 were already examined under 354C.
No,
But-
who are they?
They are school teachers, my lord. I was the headmaster, they were teachers.
And the victim is the student.
No, my lord. The allegation, if my lord comes to the FIR, I have.
Who is victim?
Victim, my lord, they say that in the office, I had taken a picture of a pregnant lady and I used to call them to my office and my lord, I have extracted the contents of the FIR. Lordship may not need the entire FIR, but point.
No,
wise-
you can tell me the gist.
My lord, I used to call the lady teachers to the headmaster's room and talk with them inappropriately. But I had clicked to a picture of a pregnant
Many lady.
lady teachers.
So there are many victims.
My lord, that is the allegation.
You are still the headmaster?
No, my lord, I have retired. I have retired.
Yes, Mr. Bhatt.
Otherwise, my lord, prima facie, it seems that on one occasion, after aiding charge of section 354A, on one occasion, accused himself has cross-examined the, my lord, PW 1, 2, and 3. I initially those PW 1, 2, and 3 already earlier cross-examined.
You have to pay heavy costs if it is allowed.
My lord. My lord, PW 1, 2, and 3, my lord, they have not been cross-examined on the altered charge. On addition of charge, my lord, under 354A, they've
That,
never been cross-examined.
that the trial court has already allowed.
But it did not permit me thereafter. On 17.
Where is the rejection order?
Yes, my lord, the impugned
1,
order,
2,
my-
and 3.
My lord, impugned order, my lord, page 50 onwards, my lord.
Or
Oh, sorry, my lord,
Page
page
45.
56. Page 56, my lord. Page 56, last paragraph, perusal of the case record, page 56, my lord. Perusal of the case record reflects that PW 1 to 6 had been sufficiently cross-examined by the defense counsel engaged by the accused. On going through PWs 1 to 6, it is seen that they've been extensively cross-examined by the learned counsel.
no,
for the
what is
accused
this
engagement.
statement? Cross-examined by the defense counsel, whether this statement is correct?
It is not correct, my lord. They were examined under 354C, on the charge under 354C, not on the added charge under 354A. The permission was granted on 17th of January.
And re-cross examination was done of 4, 5, and
No.
6
But 4, 5, 6 recross examination has not been allowed.
by you.
Cross-examination, madam, on that dates by the accused himself. My lord, which
On
is-
on the newly
Yes.
altered charges.
Yes, because that was after-
And 1, 2, and 3,
only on 354C. On 350, on PW 4, 5, and 6, my lord, they were examined by the accused himself, my lord, on 26th of July. Because the counsel was not there, I mean, could not appear, my lord. The previous counsel had died. The intermediate counsel, my lord, did not give NOC. PW 4, 5, and 6 were cross-examined on the added charge, yes, my lord, but by the accused himself.
okay, when is the next date
On the
fixed?
29th of November.
I'm just pointing out only page 45, my lord, last paragraph only. Otherwise, my lord, your lordship, yes, from the prima facie, it seems that accused himself has cross-examined and
So
examined.
if he has himself cross-examined, he
Yes,
may be allowed
yes,
to.
prejudice,
Yeah.
definitely, I am just pointing out one of the order, page 45, my lord. Why, my lord, ultimately the trial court has passed. It is to be noted that after 17-1-24, new charge added, section 354A, my lord,
Where
Yes.
are you reading?
page 45, my lord.
Yes.
I'm just pointing out to your lordship, my lord. it is to be noted that last paragraph, my lord, it is to
Okay,
be,
no, we will see the records. We'll fix a date prior to that date
yes,
so that we can dispose it off on the next day.
otherwise, my lord,
Because
pendency will also cause delay, my lord, in this one.
Manoj, the next day is fixed for PW 14 and 15, the last two PWs, next day.
that may proceed.
That
You-
will proceed, my lord. I'm not on that, but the trial may not be concluded before, my lord, allowing the cross-examination of 1 to 6.
Trial may not.
My lord, it may not be allowed to be concluded, my lord, without the cross.
How many witnesses are there?
15, they may be cross-examined, my lord, I'm not on that.
Otherwise, my lord, it would be, my lord, without.
No, we're not granting any stay.
Yes, other-
Heard Mr. P.D. Nair, learned counsel for the petitioner. Also heard Mr. P. Botakur, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioner Fazlur Rahman, impugning the order dated 1/7/2025 passed by the Court of Learned Additional Chief Judicial Magistrate North Lakhimpur in PRC case number 909/2028, whereby the prayer under section 311 of the Code of Criminal Procedure 1973 made by the present petitioner for recalling prosecution witnesses number 4, 5, and 6 for the cross-examination, and also for recalling prosecution witnesses number 1, 2, and 3 for cross-examination on newly added charge under section 354A of Indian Penal Code was rejected. Issue who is
It's the informant.
issue notice to the respondent number 2 and call for the scan copy of the PRC case, records of the PRC case number 909/2022. Today is 12. Let this case be listed on. Now, the petitioner shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 3 days from the date of this order, returnable on 28. Let us fix on 1st of December.
Month
On, then you will be knowing what happened on 28th.
or 29th, my lord.
On 2nd of December 2025. The registry to take steps for requisitioning the aforesaid scan copies. List accordingly.
The prayer for interim may be considered on that day. Can observe.
No, subject to what happens on
My
that
lord.
day, you may make prayer.
My lord, but if that is observed, my lord.
No necessity of
My,
it.
my lord, the lordship was inquiring about the bar council rule.
Yes, what it says.
My lord, rule 39 of the bar council rules, my lord, under chapter 3, an advocate shall not enter appearance in any case in which there is already a wakalat or memo of appearance filed by an advocate engaged for a party, except with his consent. In case such consent is not produced, he shall apply to the court citing reasons why the said consent could not be produced, and he shall appear only after obtaining permission.
In the court,
In the,
by the,
if the NOC is not, if the
Okay.
NOC is not.
okay,
Otherwise, it's a misconduct for which his license can be suspended.
okay, thank you.
Item 9. Deeply obliged.
May I please, Your Lordship? But in this criminal petition, I have challenged the proceeding of 127 proceeding for enhancement of maintenance, my lord.
What ground?
Earlier, my lord, the respondent filed 125 proceeding. Thereafter, after 2 years, he filed a DB case also. Now he filed one under section 127, suppressing that he earlier filed DB case and maintenance has been paid in that DB case also.
You
That was-
challenge, you appear before your 127 proceeding and make
I-
your,
I have appeared, my lord. But she, in a complaint and his evidence, he does not disclose about the DB case, my lord. And Honorable Supreme Court in Neha Rajesh versus Neha clearly stated it is mandatory to
no, you take that defense in your 127 objection. This is not a case for quashing of 127 proceeding. You can take this plea before the, instead of rushing to this court, you can take this plea before the 127 proceeding. Your ground for quashing is that she filed earlier DV case that was not disclosed in 127.
Lordship.
You take this plea in your objection. Heard. Anything more you want to submit?
Other ground is not. She regularly paying the maintenance, my lord. So, and the petitioner, he is a labor, my lord. He has no.
No,
something-
here you are challenging. Which order you are challenging?
Not order, my lord, proceeding, my lord, 127 proceeding. Page number 55.
On what ground?
On the ground that he suppressed the earlier case, my lord,
Which case?
the DB case,
In the 127 proceeding?
their lordship.
Heard Mr.
HM.
H. A. Ahmed, learned counsel for the petitioner. This application under section 528 of BNSS has been filed by the petitioner, namely Shamsung Haq, impugning the praying for quashing of the FC criminal miss case number 553 2022 under section 127 of CRPC pending before the Court of Learned Principal Judge Family Court, Borpeta. Learned counsel for the petitioner has submitted that the respondent had earlier filed an application under section 125 of CRPC seeking maintenance from the present petitioner and said on the basis of the said application, a FC criminal case number 435/2018 was registered, stopped. He further submits that said proceeding was disposed of by the learned Principal Judge Family Court Borpeta by order dated 7/12/2020, whereby the present petitioner was directed to pay an amount of rupees 1,500 as maintenance to the respondent and her minor daughter. The learned counsel for the present petitioner submits that the proceeding under section 127 CRPC has been filed by the respondent for enhancement of the maintenance allowance. He however submits that in the said application under section 127 CRPC, the petitioner has not disclosed the fact that prior to filing of the said petition, the respondent had also approached the Court of Learned Additional Chief Judicial Magistrate Borpeta, whereby by filing a case against the present petitioner under Protection of Women from Domestic Violence Act. The said case was registered as CR case number 729/2018, in which the petitioner was directed to pay a monthly allowance of rupees 2,000 to the petitioner, to the respondent and her minor daughter. He was also directed to pay an amount of rupees 20,000 as compensation under Section 22 of the DV Act to the respondent. It appears that the main contention for main contention of the petitioner is that the application under Section 127 of CRPC has been filed by the petitioner, by the respondent before the Family Court Borpeta by suppressing the material fact of instituting an earlier CR case number 729/2018, wherein in which case some amount of monthly maintenance was granted to the respondent. Stop. On a specific query posed by the petition, by the court to the petitioner, and counsel for the petitioner, he submits that the petitioner has already appeared in FC criminal miss case number 553/2022 before the Court of Learned Principal Judge Family Court, Borpeta. It is well settled. There is no dispute over legal proposition that the powers under Section 528 of BNSS has to be sparingly exercised by the court, and such and the powers under said jurisdiction may be invoked only when there is possibility of apparent denial of justice or some gross illegality on the face of the record. In the instant case, the petitioner can very well place his case before the trial court in FC criminal case, criminal miss case number 553/2022. And hence this court is not inclined to invoke its jurisdiction under Section 528 of BNSS under the facts and circumstances of the said case at this stage. This application under Section 528 of BNSS is therefore dismissed without issuing notice to the respondent.
Dispose of
You place your case before the,
that observation may begin and dispose of.
there is no bar. No, it has to be dismissed.
Item 10. Publish.
Under 528 of BNSS, my lord. For watching the entire proceeding of PRC case 725 of 23 pending before the subdivision business state, Joe Hartman. My lord, under 528, my lord, this proceeding is, my lord, the abuse of the process of the court, my lord, and for the ends of justice, the petition is filed. Because, my lord, may I go to the FIR, my lord, page number 11, my lord.
No, what is your case? First, you tell me the gist.
My
Why,
case-
why it should be
Yes,
quashed?
my case is that, my lord, on two grounds I have appeared before this court, my lord.
Yes.
Number one, my lord, that this petition is filed, my lord, it is a proceeding is the abuse of process of court
How?
because, my lord, I have the, my lord, documentary evidence, my lord, I have annexed with this petition that on the very date, my lord, at 7:30 AM, my lord, I have been, I am an Indian Army personnel, my lord, and working as a nursing assistant. I was sent to Numaligarh from Jorhat, my lord, at 7:20 AM, my lord, in the morning, my lord. I have the documents, my lord.
No, you can take the plea of alibi before the trial court.
Yes, my lord.
This court will not try the case
That is-
and
that
go
is-
into the facts.
That is right, my lord. And my lord, because my lord, since there is a clear, my lord, documentary evidence, my lord, I have annexed with this honorable court, my lord, by collecting through RTI, my lord, from the department, my lord, that on the morning I had left, my lord, and after 3 days I have returned, my lord, it is on record, my lord. I have annexed, my lord. And another fact is that, my lord, after 9 months, my lord, without any explanation, my lord, this FIR is filed, my lord, page number 11, my lord. Page number 11. my lord,
Those cannot be ground in a 528 application.
Prima facie, my lord, the FIR itself, and prima facie, my lord, my lord, it is a,
Where is the affair?
well, page number 11, my
Now,
lord.
there's present status is page 36 is relevant. ma'am.
11, my lord, is the FIR. It is a translated version, my lord. May I read, my?
Possible physical relationship on 8/9. The date of incident is 8/9/2021.
8, 9, well, page number 12, my lord. Page number 12 is the registered on, FIR is lodged on 12/6, my lord. 12/6, page number 12, my lord. After 9 months, my lord, and in the FIR it is mentioned that, my lord, she informed his husband on the same day, my lord.
No, we cannot verify the facts in a 528 petition. Apparently, an accusation has been made against you.
Yes.
You are saying that this is not true.
Not true, my lord.
That defense you have to take before unless there is some,
That the evidence, my lord,
your submission is that you have a defense of plea of alibi.
yes,
You were not there,
yes, my lord.
but that you have to take defense in the trial court.
Yes, my definitely, my lord. Page number 38 for a moment, my lord. Page number 38, that is the document, my lord. I have, my lord, annexed, my lord, page number 38 through RTI. It is included. Page number 38, my lord, it is a document. Then a daily parade state of headquarter team as on 8 September 21. Your lordship got it, my lord. Page number 38. Page number 38, my lord.
At what stage it is pending?
My lord, page 36, my lord, petitioner was, my lord,
My lord, this for my lord,
given
appearance,
last
my lord.
chance for appearance, my lord.
Appearance, my lord.
Third, peruse the petition last, considering the ground mentioned, the same is allowed with a last chance to appear on the next date with a strict direction to remain present on the next date without fail. Else the
This
case
is
will-
not a case.
My lord, in February, my lord, he has been transferred to Agra, my lord, February 23, and charge sheet is filed in August, my lord. August 2023, my lord, she will find a charge sheet, my lord, page number 17, my lord.
No, these are beating around bush.
No, my lord, regarding
You
my
are
lord,
not coming to the point.
point, my
On
lord,
what?
my lord, I have few decisions of the Honorable Supreme Court, I will place a lordship, my lord. That, my lord, facing the trial, my lord, it will also, my lord, my lord, abuse the process of the court. my lord.
Maybe, but before that, you have to make out a case
Yes.
for interference by this court under section 528.
My lord,
You are showing your defense.
my lord, it is prima facie that, my lord, the petitioner was not present, my lord. It is a false case, my lord. It is proved, my lord, by my documented evidence, my lord. A false case is proved by the documents, my lord, by the petitioner, my lord. Page number 38 is the documents by the department, my lord, issued. Then on 7, my lord, on page number 40, my lord, your lordship will find at 7:29, I have reported, my lord, to my major, my lord. Page number 40, my lord. in a WhatsApp message to the major, I have.
No, the veracity of these documents will be tested during trial only. By merely producing a document, you cannot. This is your defense. The petitioner may have something to say on the veracity of these documents.
Yes, but my lord, facing trial, my lord, it is also abuse the process of the court, my lord, in this case, my lord. Since there is prima facie, my lord, petitioner was not present, my lord. So at this stage, may I pray for a notice, my lord, at this stage?
No
And
notice.
till returnable date, my lord.
No
this
notice.
Otherwise, my lord, it will be a process, abuse the process of the court, my lord. I will place, my lord, the honorable apex court.
You don't have a case under 528.
But my lord, I
He
will
himself
place, my lord,
involved in abusing the process of the court by not obeying the court for that.
Yes.
I may.
By filing a vexatious 528 petition, that also amount to abuse of process of.
My lord, I have the page 38, my lord. The document, my lord, where, my lord, it is prima facie, my lord, page 38 for a moment, my lord. That, my lord, on 8th September, my lord, in the first, second, third, fourth column, my lord, for a moment, my lord, fourth column, page number 38, my lord. Page number 38, fourth column, my lord. The number 3, my lord, my name is Lalit, my lord, nursing assistant Lalit. 3, 4. My lord, OPS out. Your lordship will find page number 38, last but one column, my lord. My name is serial number 3, my lord. Along with 2 other personnel, my lord, I was sent to Numaligarh, my lord, on 8th September at 7 AM, my lord. And the allegation is, my lord, 8th September, 11:30 PM, my lord. So 11:30 PM, my lord, on 8th September, the allegation is there. And in the morning, my lord, 8th September, I was sent to the Numaligarh, my lord. And my lord, on the next page, your lordship will find on 11 September 39, page number 39, my lord. I, my lord, reported on 11 September to Jorhat in the first column, my lord. First column, my serial number is, my lord, 4. My serial number 4, my lord. 11 September, I reported, my lord, in the Jorhat, my lord. Jorhat reported returning from Numaligarh, my lord. So this document is prima facie, my lord, shows that this is a false FIR, my lord. On 7:30 AM, I, my lord, sent to the Numaligarh morning, and it is, my lord, 11:30 PM, the allegation, my lord, in the night, my lord. Fag, and that is after 30 minutes, it will 9 September, my lord. So on 8 September morning, my lord, the documentary evidence proved that, my lord, I was not present, my lord, on that day, my lord. And this document is issued, my lord, under RTI, my lord. And in this regard, my lord, may I place, my lord, few, my lord, only two judgments of the Honorable Apex Court, my lord.
What judgment? Yes, Mr. Bhattakur.
My lord, distance between Numaligarh and Jorhat is only 40, it will take only 45 minutes. Now, suppose in this petition, he has annexed this document,
So
anyone
it
can.
is not an impossibility.
Yes, my lord.
that after
Anyone can commit an offense at 11:30 PM and immediately thereafter return back to Jorhat, my lord. My lord, why he is annexing this document, my lord, in a case which FIR law after investigation search sheet submitted, now court has taken cognizance from since 2023. He has not appeared, now making all these allegations. Let them place all these documents at the time of framing charge, my lord. So, my lord, this petition is, my lord, there is no ground at all, my lord, liable to be rejected. Dismissed, my lord.
Heard. Mr. A. What is this
My
document?
lord, my citations, my lord, one is, my lord, of the Pradeep Kumar, my lord, Kesarwani case, my lord.
What you are relying?
My lord, page paragraph number 14, my lord, may I refer, my lord? Sorry, my lord. Pradeep Kumar.
Yes. Which where are you relying?
My lord, in your lordship, what, my lord, the Pradeep Kumar case, my lord. My lord, paragraph number 17, my lord. May I read, my lord?
During investigation, whether you were examined,
No, my lord. Not my lord.
you are shown as an
I was not
absconder.
arrested, my lord. I was all along present, my lord, till February.
You are shown as an absconder in the charge sheet.
Charge sheet, but my lord, I was present till February, my lord. I have
Yeah.
mentioned in my petition, my lord.
Absconded.
In February, my lord, I have been transferred to Agra, my lord. Presently, I am serving in Agra, my lord. In Agra, I have received the charge sheet, my lord. And charge sheet is filed in August, my lord. So February, I have been transferred, my lord, in Agra, my lord.
This is not a case.
My lord, paragraph number 17, may I read? The duty, my lord, your lordship will find.
Yes.
17, the duty of the court in cases where an accused seeks quashing of an FIR, lordship got it, my lord.
Yes.
Or proceeding on the ground that such proceeding are manifestly frivolous or vexatious, or instituted with an ulterior motive for wreaking vengeance was delineated by this court in Muhammad so and so and so. and so.
But these are not your plea. Your plea is that you are taking plea of alibi, that you were not present. That
Yes.
is the only defense.
Yes, my lord, that is proof, my lord, that the FIR is false, my lord. FIR is false, it is proved, my lord. 11:30 PM, my lord, suppose my friend stated that.
On the basis of some document which are yet to be tested, veracity of which is to be tested,
Yes, my lord.
whether those documents are.
Yes, my lord, for which, my lord, I may be, my lord, only notice may be issued, my lord, in this point, since there is a, my lord, a prima facie case, my lord, regarding vexatious, my lord, the frivolous FIR, my lord. Only, my lord, the notice may be issued, my lord, and till then the proceeding may be stayed, my lord. And my lord, if your lordship is not satisfied, my lord, then, my lord, in the later state, it may be, my lord, dismissed, my lord. But at this stage, my lord, there is a document I have produced, my lord. On the basis, my lord, is found that my friend stated that 45 minutes is taken, my lord. Then 11:30, after committing the offense, I reported my unit, my lord, in the army, Jorhat, my lord. Then I have sent to the Numaligarh, my lord, on the 8th, my lord. It is not possible, my lord, practically, my lord. And my lord, your lordship will find on the 7:29 AM, I have reported my major, my lord. The major, my lord, endorsed in the message, my lord, in the WhatsApp message, my lord. The major has, my lord, endorsed that I have reported, my lord, 7:29 AM, my lord. So, my lord, facing trial in this case, my lord, it will amount to, my lord, abuse the process of the court, my lord. Your lordship will find the last page number 40, my lord. Major
No.
S. Sarath, my lord. S. Sarath, my lord, endorsed this, my lord,
No.
message, my lord, page number 40. This message endorsed by the major, my lord, of the unit, my lord. That I have reported at 7:29 AM, that, my lord,
On the next day,
my lord,
7:29 on
the same date, 8 September, my lord, I have 7:29 AM. My lord, page 40, my lord. I have reported my major, my lord, 8 September, 7:29
No,
AM.
that is a WhatsApp message only.
He certified, my lord. My major certified, my lord, that Major S. Sarath has certified this, my lord. He is the major to whom I have reported, and he certified this, my lord. And prima facie, this proof that the FIR is, my lord, is a frivolous FIR, my lord. The major himself, my lord, endorsed this, my lord. The 7:29, I have, my lord, I have informed that, my lord, that I have lockout for Numaligarh, my lord, 7:29 AM. An allegation, my lord, 11:30 PM, my lord, in the night. After committing the offense, my lord, how is it possible to return to the report to the unit, my lord? And then I have been, my lord, sent to Numaligarh, my lord, on this within half an hour, my lord, 8 September, my lord. My lord, these documents, my lord, prima facie proves that, my lord, this FIR is a frivolous FIR, my lord. And, my lord, the petitioner is posted at Agra in UP, my lord. He will face the trial at Jorhat, my lord.
No, this is your defense only. Yes, Mr. Bhattakar.
Otherwise, my lord, considering all these facts, my lord, this petition is liable to be dismissed with cause.
Dismissed.
My lord, I have produced the documents.
No,
my lord.
I will write orders in chamber, go through the detailed order.
At least, my lord, a notice may be
No
issued.
notice,
For time being, my lord.
no notice. Dismiss, reasons will be mentioned. Next
Or my
item.
lord, in this, my lord, under 528, my lord, your lordship of inherent. my
I
lord,
will mention the reasons in my judgment.
My lord, otherwise, my lord, your lordship may, my lord, some protection may be granted to appear, my lord, before the. court, my lord.
After,
It would- Next day is the date, my lord, for
no,
appeal.
for that you have other reliefs. You appear before the trial court on the next date fixed. But your quashing this petition is dismissed.
My lord, then my lord, the petition may be taken up on Monday, my lord.
After dismissal, you have to file, you have to go to Delhi. You wait for a detailed order.
My lord, may be taken up on Monday, my lord.
I have already dismissed it.
Yes.
Yes.
Today, tomorrow is the date fixed, my lord. Otherwise, if the petitioner appear, my lord, he will be taken into custody, my lord, by the SDJ. If 370, some protection may be.
I will address all your submission in my order. Yes, next item.
May I please move it? Okay, I have a limited prayer lordship in an NI case proceeding lordship. When I pleaded guilty, I paid payment to the complainant also, but on 8/10/2024, NBW was issued against me lordship. And thereafter several dates has been elapsed lordship, I could not appear as because I had no knowledge regarding the issue of NBWL. Lordship, now I am ready to appear before the trial court lordship. And till then, lordship, NBW may be suspended. I may be.
When is the next date fixed?
Next day is on 6th of January 2026, lordship.
Yes, Mr. Bachchan.
It's a complaint case, lordship.
It is a complaint case.
My lord.
NIK.
And I,
Why have you not appeared?
lordship, my earlier counsel did not take steps on that particular date, although I have intimated her. Thereafter,
How much is the amount involved?
5,87,500, lordship.
You have to pay the cost. Pay some cost to the complainant. He has suffered because of your negligence.
Yes, lordship, I will ready to pay the cost.
Heard Mr.
KK Hendrik, lordship.
A.K. Hendrik, learned counsel for the petitioner. This application under section 528 of BNSS has been filed by the petitioner, namely Kogen Kumar Bora, impugning the order dated 8/10/2024, passed by the and subsequent orders passed by the Court of London Subdivisional Judicial Magistrates within bracket S
Number 1.
number 1 Kamrup Metro in CR case number 3124/2022, whereby non-bailable warrant of arrest were issued against the present petitioner. Learned counsel for the petitioner has submitted that the respondent, Shri Jiban Kumar Krishna Das, has lodged a complaint under section 138 of Negotiable Instrument Act 1881, and on the basis of which CR case number 3124/2024 was registered. Learned counsel 2022 was registered. Learned counsel for the petitioner has submitted that you have received the summons. Have you,
We received the summons
and you engaged the counsel also,
also.
though the petitioner,
And I pleaded guilty also, lordship.
and thereafter,
After I made some payment to the complainant also, lordship.
though the petitioner on receipt of the summons from the trial court appeared before the trial court and pleaded guilty of offence under section 138 of NI Act on 28/7/2023 and promise to pay the outstanding amount in installments. And however, after paying few installments, he defaulted. Why you defaulted?
Lordship, on another date fixed, Lordship, my counsel did not took any steps.
Defaulted on 8/10/2024 as he was not informed about the said date by his newly engaged counsel. Neither the said counsel took necessary steps before the trial court. Learned counsel for the petitioner has submitted that the petitioner is ready to appear before the court, Court of Learned, SDJMS, Kamrup Metro, in NI case number, in CR case number 3124/2022 on the next date fixed. That is on 6/1/2026 and comply with the court's order. Stop. However, as non-bailable warrant of arrest has already been issued against him, he needs some interim protection in this regard. Stop. I have considered the submissions made by learned counsel and have perused the records. Stop. Considering the submissions made by learned counsel for the petitioner, as well as also considering the fact that the petitioner is ready to appear before the court on 6/1/2026, that is the next date fixed on in CR case number 3124, and is also ready to pay the cost which may be imposed by this court. This criminal petition is disposed of with a direction to the petitioner to appear before the Court of Learned Subdivisional Judicial Magistrate, Sadar, Kamrup Metro, in CR case number 3124/2022 on the next date fixed 6/1/2026 and comply with the court's order. So to facilitate his appearance before the said court, the operation of non-bailable warrant of arrest issued against him is hereby kept in abeyance till 6/1/2026, subject to payment of a cost of rupees, subject to deposit of a cost of rupees 5,000 to the, when will you deposit the cost?
On that same date, Lordship.
To the in the court to be paid, to be given to the respondent on that day by the said court. Stop. With above observations, this criminal petition is hereby disposed of.
Deeply obliged.
Item 12.
May I please? Submit?
Yes.
Lordship, in this case, the last page of the impugned order, which is at page 41, Lordship, that has been left out to be annexed, Lordship. Therefore, kindly pray before your Lordship to allow me to file an additional affidavit so that the impugned order is being kindly annexed, Lordship.
Heard Ms. S. Yasmin, learned counsel for the petitioner. Your state is a party.
State is a party,
Also heard
formal
Ms. Also heard Mr. K. Bashir, learned additional public prosecutor. Learned counsel for the petitioner submits that inadvertently the last page of the annexation impugned order which has been annexed along with the criminal petition could not be placed with the case record. Hence, she prays for allowing the petitioner to file an additional affidavit to bring on record the said documents. The prayer is allowed. Let this matter be listed in the next week on a date to be fixed by registry.
May it please, your Lordship. Here, my lord, we are challenging in 126 proceeding, my lord, 126 BNS, which was earlier, Lordship knows on 107, my lord. Here, my lord, the learned executive magistrate, my lord, he beyond, my lord, his powers vested under section 126 BNSS, my lord, he directed for demarcation, my lord, where he ought to have only signed, he has, the first portion, he has allowed both the parties to sign, file a bond, my lord. But beyond that, for demarcation, my lord, it is beyond his power. Lordship knows 126, my lord. He cannot, my lord. 126 only, my lord, both the parties may be, my lord, directed to sign bond, my lord, or bail bond, my lord, to maintaining peace, my lord.
Where is the impugned order?
Impugned order, page 10, my lord. Page 10, my lord. Here, my lord. Here, my
But
lord.
demarcation, otherwise executive magistrate can.
For demarcation, my lord, because the respondent number 2, my lord, he resides at Tasteful. For that, he had to file a civil suit for claiming his land or a partition, my lord. He should approach a proper civil court of competent jurisdiction. But he has found a shortcut, my lord. He has applied for 126, which was earlier 107. Then signing of bond is okay, my lord. But my lord, page 14, my lord, the relevant portion, my lord. The other, my lord, the order of demarcation, my lord, to the circle officer writing the OC.
Where?
Page 14.
Oh, yes.
Page 14
Without
now.
filing a civil suit.
1, 2, 3, 4. Without filing a civil, he stays at Tezpur, my lord, the respondent number 2. Then my lord, 1, 2, 3, 4, my lord, the circle officer Samagri to depute concerned land record assistant for demarcation of land boundaries. OC Rupoya to deploy educate police personnel during the demarcation process. So my lord, this is my lord, and lordship knows 126 only bond, my lord.
Okay. Heard Mr. P.
SM Abdullah.
Yes, SM Abdullah P. Learned counsel for the petitioner. State is a party.
State is the just a namesake party, my lord.
Also heard Mr. K. Bashir. Learned. You have anything to say?
Here is the case of, my lord, there is the right title and, my lord, the declaration of right title and interest.
Civil suit is pending.
My lord, civil suit to pending.
No,
Civil suit is not there, but my lord, that is in the page 10 of the, my lord, the impugned order. The subject matter of the dispute is the inheritance of ancestral property, which is led to breach of peace and public tranquility.
But here
Race
cannot-
part is there, but my lord, that is because it is coming from the inheritance, my lord. So that is the, my lord, the civil court is the authority, my lord.
Yes. This application under section 528 of BNSS has been filed by the petitioner Shri Dilip Sarkar, impugning the order dated 10/10/2025 passed by the learned executive magistrate Kolyabad, Nagaon in MR case number 116/2025 under section 126 of BNSS, whereby 126 of BNSS stop. Learned counsel for the petitioner submits that the respondent number 2 had filed an application on the basis of which a proceeding under section 126 of BNSS was initiated. He submits that the proceeding was filed, the application was filed by the petitioner on the ground that there is a possibility of breach of peace and public tranquility in relation to a dispute between the parties over inheritance of ancestral property. He submits that by the impugned order, though the learned executive magistrate directed both the parties to execute bonds for keeping peace. However, it exceeded its jurisdiction under section 126 of BNSS by directing the officer in charge of, by directing the concerned circle officer for demarcation of the disputed land as per relevant mutation order, so that legal successor of the predecessor in interest of the present petitioner may receive their rightful shares. He submits that by doing so, the executive magistrate had delved upon the domain of a civil court and exceeded his jurisdiction. Stop. Issue notice to the respondent.
Respondent number 2 point.
Respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 by speed post within 7 speed post as well as by usual mode within 7 days from the date of this order, returnable on 18th of December. Also call for the records of MR case number 116/2025 from the from the Office of Learned Executive Magistrate Kolyabad. Registry to issue requisition, take steps for requisitioning the aforesaid record. In the meanwhile, considering the submissions made by learned counsel for the petitioner as discussed in the foregoing paragraphs, this court finds prima facie and as this court finds prima facie as this court finds sufficient force in the submission of force in the contentions raised by the learned counsel for the petitioner, further proceeding, the impugned order dated 10/10/2025, the execution of impugned order dated 10/10/2025, to the extent whereby it has directed the circle officer to
14 minutes.
to demarcate the disputed land shall remain stayed until till next returnable date. List accordingly.
Oblige, your lord.
May I please, your lordship? Lordship, may kindly allow me to withdraw this petition with liberty to file it.
Why?
Lordship, here, lordship, we are relying on a document that is the birth certificate of the victim, but unfortunately, lordship, I have not annexed that. The victim is the wife of the petitioner, lordship. This is squashing, lordship, of child marriage.
Heard. Mr. M. Ahmed, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant criminal petition as some important document on which the petitioner is relying has not been annexed in this case. He seeks liberty to file an appropriate application in this regard. The prayer is allowed. This criminal petition is dismissed on withdrawal with the liberty sought for allowed.
Highly. Item number 15.
None has appeared for the petitioner on call. Let this matter be listed in the next week on a date to be fixed by registry.
Item 17.
Madam, we pass over for the time being.
After something.
Item 18.
May I please? Lordship, quashing, this is for quashing of an FIR, Lordship. The petitioner number 2 in this case, sorry, the petition number 1 in this case is the accused of the instant FIR. Petition number 2 and 3 are the complainants of the instant FIR, Lordship, and Lordship will find the FIR at page 12.
What is the stage?
Lordship, it is an investigation stage. The matter is being compromised between the accused and the complainants, between all the 3 petitioners, Lordship.
What ground is compromise, but this offense is non-compoundable. You are on bail.
Yes, Lordship. I have annexed the order.
You are on bail. The petitioner. Okay, we'll examine the issue. Heard. Miss S. Yasmin, learned counsel for the petitioner. Also heard Mr. K. Bashir, learned additional public prosecutor. This application under section 528 of BNSS 2023 has been filed by the petitioners praying for quashing of the FIR dated 5/9/2025, on the basis of which dispute PS case number. What is 305E?
305E is theft of property of government, Lordship.
308?
308 is extortion.
Calculus. Dispute case number 748/2025 under section 305E/308 within bracket 4/61 within bracket 2 of BNSS. Learned counsel for the petitioner has submitted that the petitioner number, who is the first informant
Sonu Ali, the petition number 2 in
and who is the number 3?
Rinku Burman.
Who is he?
Rinku Burman is the friend of Sonu Ali. Rinku Burman was informed about the incident by the petition number 2. So since he knew the incident, he also became the complainant of the FIR.
It is submitted by learned counsel for the petitioner that petitioner number 2, Sonu Ali, is the informant of the case. Informant of the first information report on the basis of which the aforesaid PS case was registered. Whereas petitioner number 1, Ratul Deka, is the accused in the said case. She submits that as the matter has been amicably settled between the parties and the first informant does not intend to proceed with the case, this instant criminal petition has been filed. stop. Stop, let the case diary of Dispur PS case number 748/2025 be called for. Let this case be listed again on
Any date matter as per convenient of your lodge.
26th of November.
Great.
List recording.
Right.
Placed Lordship.
That is a lot. This is for Chelonian, my lord, order of maintenance, my lord. Let's take you. Page 24, my lord, I'll just take you to the petition once. Paragraph 2 of this complaint petition, 125 petition.
Your husband,
I'm the husband. In fact, I'm not the husband. My lord. Yeah, we are not even, my lord, husband and wife. There's no question of staying together as well. She was already married with 2 children. Now, this case, all of a sudden has come up, my lord. In fact,
no, this is an ex parte order,
no, not an
contested order.
expert. This contested.
What was the contention of the petitioner before the trial?
Her
No, contention of the
only wife.
respondent. She's claiming to be your wife.
Yes, and lordship will kindly see page 24. I'll just take you for a moment, my lord. Paragraph 2. This is the, my lord, complaint petition, 125 petition, my lord.
Yes.
That she was married to the opposite party on 4/6/2017, according to the Islamic rites and rituals, and since then they are living together as husband and wife in a rented house at Maligaon, as because the relationship was not accepted by the parents of the opposite party. Now, lordship, I'll just take you to page 29. This is the written statement. We denied the marriage, my lord. Paragraph 4, page 29.
Yes, you denied the marriage.
Yes, denied, my lord. At her marriage, third line, you know, that her marriage was solemnized on so and so according to Muslim rites and rituals, as because Mamuni Biswas is a Hindu woman by religion, and there is no any conversion documents along with the main petition, and her name and title has not been changed.
What the court has
Well,
held.
my lord, here on the basis of, my lord, on the presumption, my lord, the court has come to a conclusion. I'll take you to one more thing, my lord, like just page 40, my lord. Is a cross-examination of the wife, alleged wife. Page 40.
Yes.
Second line, my lord. I was staying at Maligaon BBC colony after having married with the opposite party. I was taken away by the opposite party forcibly and started living as husband and wife. This has come new, my lord. But no social marriage was solemnized between us. No marriage of in any form was solemnized, but we were living as husband and wife. I cannot remember the date on as to when I was taken away by the opposite party. Now, if your lordship kindly comes down below, 6th line below, I have filed divorce case. In fact, my lord, she claims to have married me, my lord, on 4/6. Whereas, my lord, divorce was granted from her earlier husband on 30/11/2018. She claims to have married me at where her marriage was substituted. That in fact, my lord, even she is getting maintenance. She is getting a lot. In fact, another thing, my lord, the statements of affidavit of statements of liabilities, my lord, that your lordship will find at page 58 is of the husband, my lord, alleged husband, the petitioner here. The court came to a conclusion, my lord, that this affidavit, the affidavit assets and liabilities were not filed by the petition. This was not taken into account, and in fact, my lord, page 67 is the assets and liabilities of the respondent here, my lord. The cross-examination was of, my lord, way back, my lord. It was on May 20, so cross was on 29/5/23. And this asset liability statement was filed in the month of May, my lord. And lordship will see date of marriage, lastly, my lord, 4/6. And there is no disclosure of the earlier marriage, my lord. Entirely a false case, my lord.
And if your lordship kindly comes to page 69,
How much?
Ten-
No,
7,000 and 3,000, my lord,
children is also.
with the children also. My lord. There is no connection, my lord. How come, my lord, and in fact, lordship will see the falsity, my lord. Page 69, she says, details of children of the parties, 1.
Any execution case has been filed. We are issuing notice.
File, file.
We are issuing notice. Heard,
We have already appeared, my lord, that's what,
where?
in the execution procedure.
Heard Mr. R. D. Learned Counsel for the petitioner. So your contention is that trial court wrongly,
Yes, sir. In fact, even the statements of assets and liabilities were not taken into account, my lord. Even, my lord, basically on the basis of presumption, my lord.
heard Mr. R. D. Learned Counsel for the petitioner. This application under section 438 of BNSS has been filed. Why 438?
It was earlier 397, that was the 397.
419 of Family Courts Act is there. Oh, Family Courts Act. Give them. Whether division can be filed under 419 or what is the provision? Appellate provision. No, 19, 4.
The High Court may also motion for approval. Not being an interlocutor.
The provision for revision is there.
There, understand. I want to ability in property.
Okay, we are treating it to be
Lordship, deeply applies.
section 438 of BNSS. Impugning the judgment and order dated 29/7/2025 passed by Learned Principal Judge Family Court number 1 Kamrup Metro in FC criminal case number 382/2022, whereby the petitioner was directed to pay a monthly maintenance amount of rupees 7,000 to the respondent and 3,000 to her minor son. The contention of the petitioner is that the respondent was not a legally married wife of the petitioner, and they never stayed together as husband and wife. And the said contention was, and said aspect was not taken into consideration by the trial court. Stop. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent by register, by speed post, as well as by usual mode within 7 days from the date of this order, returnable on the 8th of, when is the next date in the execution?
1911.
Execution case?
1911.
On 8th of December 2024. 2025. Let her appear.
No, give them, my lord, otherwise. Will completely, my lord.
We do not know her story.
But lordship, on the facts of it, no. She says, she claims to, then she says, I was never married. She makes a statement on oath. She says that I am married, then she says there was no marriage at all. Both are on one affidavits.
Let her appear on 2nd of December. The prayer for interim relief would be considered after due service of notice on the respondent.
Right, my lord. My lord, I have taken instruction, my lord, petitioner before your lordship is already on bail, my lord. So, my lord, notice maybe should stay is not necessary, my lord.
But whether it is a case where notice should be issued or not.
My lord. They are married, my lord. Child is also there, my lord, and they are Muslim, my lord.
Oh. Now, what is your ground for?
Crown lordship, I have for ready reference, my lord, one judgment I have in a lordship.
No, before judgment,
Oh, my
on
lord,
what ground you are seeking quashing?
yes, my lord. The ground is that, my lord, they were loving each other, my lord. Initially, they once eloped, my lord. But police caught him, my lord, and sent to my lord, jail, my lord.
Now, what is their relationship, husband-wife?
Husband, wife. Subsequently, where she was being married elsewhere, my lord. They, my lord, again eloped, my lord, and married, and they are happily maintaining their family life. And one
Now, what is their status?
status husband and one child is also there.
Who is Hussein Ahmed?
Hussein Ahmed, my lord, the father, my lord, the
Okay,
informant.
okay. Heard Mr. A.M. Borbia, learned counsel for the petitioners. Also heard Mr. P. Bhattakur, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioners praying for quashing of the special POCSO case number 43/2024 pending before the court of learned special judge where
My lord, the additional session judge, special judge, my lord, Kachar, Silchar, my lord.
additional session within bracket special judge Kachar Silchar. What is the status?
My lord, the status, my lord, he could not meet with his advocate, my lord. There is an advocate, my lord, but appearance stage, my lord. It is.
Stop. Issue notice to the respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 by speed post as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks, and returnable on 16th of December. Let the scanned copy of the trial court records as well as the scanned copy of the connected case diary be called for the registry to take steps for requisitioning the scanned copy list accordingly.
Apply.
Item 54.
Made. That the petitioner is a 72 years old, lord. He was a retired principal. He retired in the year 2014 from a college. Now, after 5 months of his retirement, the in-charge principal lodged an FIR against him, alleging that the amount received by him during his period from the UGC University Grant Commission was misappropriated. Now,
Now, on what you are, charge sheet has been laid.
late, lordship. Now, otherwise the case was posted for consideration of charge. Now, because the documents which were favorable to the accused was not furnished, he filed a petition. All those in the seizure list, those documents were mentioned, but those were not furnished. So ultimately, the case is fixed on 17/12/25 for necessary. I filed a petition. There was a hearing on the petition. as the police could not file or public prosecutor could not furnish the copy, so the now case is fixed for on 17/12/2025 for necessary order on the petition. Now your lordship will find
Now, what is your ground in this case?
there was no misappropriation at all. After receiving the amount on installment, because UGC does not release the entire amount at a time. Utilization certificate has to be furnished.
You can
after
play, you
inspection.
can make these submissions before the,
Lordship, there's ample evidence, lordship, your lordship will find this person, the informant, he was a member of the construction committee, lordship will find at page
no.
30. Therefore, I have
Mr.
submitted-
Alam, I am
Yeah.
on a different
No, have to-
line. So the case is now fixed for consideration of
no, sir,
charges.
lordship.
You can produce those documents.
Because those documents were not furnished,
It is fixed for necessary orders.
necessary order.
If it is furnished to you,
The pain of the
no,
criminal
no,
trial.
no, not criminal trial. If those documents are submitted, furnished to you, you can rely on those documents for your defense during your plea for discharging.
Lordship, what happened, Lordship, with all respect, Lordship, this investigation was conducted in a partisan manner to favor the informant, to falsely implicate the. Lordship will find some documents were certified by the police because those documents were obtained. All the utilizations of even completion certificate, I have annexed the completion certificate certified by the Velsar police station. Those certificates were submitted before the UGC, proper authority. From the authority during investigation, police obtained those documents. There is a RTI application on the basis of RTI.
No, is it your case that during investigation, such materials were collected by IO,
Did
which,
not rely.
which would indicate that there was no misappropriation,
Exactly.
but the IO did not rely
Did
on.
not rely those documents just to implicate me. Otherwise, he could not implicate me.
Okay, yes.
I'll take your. Yes.
No, we'll examine that.
Yes, that has to be examined, Lordship.
Heard Mr. Z. Alam, learned counsel for the petitioner. Also heard Ms. P. Bhattakur, learned additional public prosecutor. When is the next date fixed?
It is on 17/12 for this thing.
Necessary orders.
Necessary.
528 of BNSS, praying for quashing the entire proceeding of PRC case number 713/2024. The said proceeding arose out of Belsar PS case number 107/2025. 15 under section 175/409/420/468/471 of the IPC. Learned counsel for the petitioner has submitted that the main accusation against the petitioner in this case is of misappropriation of fund allocated to the college of which the present petitioner is a former principal, was a former principal by the petitioner. He, however, submits that no such misappropriation was done by the petitioner, which would be revealed from the documents collected by the investigating officer during the course of the investigation. He submits that though investigating officer during the course of the investigation collected documents and such materials which would have indicated regarding the innocence of the present petitioner, the investigating officer, in a partisan manner, filed the charge sheet before the trial court. He further submits that the petitioner has prayed for furnishing of those documents which were not relied upon by the trial court, and the trial court has reserved the order on his petition by fixing the matter on 17/12/2025.
Right.
Yes, Mr. Bhatt.
Otherwise, my lord, here in this case, there are three allegations, not only misappropriation regarding at the same time drawing salary and at this also pension, my lord, and changing the date of birth in the service records also. These are three allegations. And now-
Thoroughly.
Now, my lord, case is already, at this stage, this petition is premature because that order is already, trial court has fixed regarding those, regarding those grievances on for necessary order, it is on 17/12. So only after 17/12, my lord, and after framing a charge not yet framed, my lord, let him place all these points, my lord, and along with all these grounds. he may
Power
be
of
discharged,
the
my lord.
consideration of charges is very limited. 482 is different. Here, the trial court to
No,
consider only the
okay.
material available.
You
in
are
the
on bail.
record. Lordship,
You are on bail.
Lordship, I'm bail.
The
But
contention,
limitation of Trial court is very limited.
the
Lordship.
contentions raised by the petitioners are required to be examined. Hence, let the scan copy of the PRC case number 713/2024, along with the scan copy of the case diary of Bills or PS case number 107/2015 be called for from the trial court. Let this matter be now. Let the notice be issued to respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 15th of December 2025. List accordingly.
In the meantime, Lordship, I'll take your Lordship to the page number 54, Lordship, for once
Now, what do you want?
further proceeding may be stated. Lordship.
Your date is on 17th. We are
No,
fixing it on
I'm-
15th.
Because is on that, power of 580.
No, we are fixing it on 15th.
15, Lordship.
15. Let the CD comes, then we will examine
Your
whether,
lordship, fixed in after 17, my lord, because that.
no, after, before 17th. If we do not find material, we may dismiss the,
Lordship will kindly see for my satisfaction, Lordship, page 54. Page 54, just for a moment. Lordship. Page 54 is the completion certificate, and this copy was issued by the officer in charge. And he is saying that I have misrepresented the money. This is the,
no, the case is fixed on your application for furnishing of
furnished-
documents.
decide the
Document.
merit of the case. That is the problem. That will not. decide.
Let us go through the case diary.
In the meantime, Lordship may stay.
In the meantime, the case will not be listed. The question of stay does not appear. In the meantime, the case will not be before the court. Case will come up after the next date fixed by this court. So question of stay is immaterial.
Finding item 17.
My lord, page 19 is the impugn order, annexure 2. Here, my lord, the learned trial court at 1 PM have closed the cross examination of PW5 dispense, my lord, under section 3092 C, small c of CRPC, and one of the witnesses was sent back with a and he was called again, and cost was imposed 2,000 cost, my lord.
Page
Now, my
number-
lord,
Page number
page 19.
is the impugn order.
Impugn order. Now, my lord, this impugn order on the law point itself, my lord, it goes because 3092, which is not operative as on date, cannot be invoked. It could have been under any section of the BNSS. 309, my lord, this observation has to come. We are coming through many cases are there. FIRs are being registered under IPC. Proceedings are being carried out under the CRPC. My lord, these acts are not there. We have to understand that now. Any law has to be imposed in letter and spirit. When these sections are not there as on date,
Now, my lord, they are using these sections, my lord, a direction should go, my lord, to all the learned trial courts below, my lord. That they stop using the CRPC and all. Very well, my lord, we understand. This court can understand this section in relation to the section in the BNSS very well. I am not on that, but lordship, a direction may kindly go, my lord. We are facing lots of problem in the learned trial court, my lord.
There is a judgment of this court as to in which cases, division bench judgment, which cases the provisions of BNSS would be applicable, in which cases CRPC. From when?
But this
You
case,
have that judgment.
Yes, my lord, that,
the judgment is there, my lord.
You have the copy of that judgment. We will, this has not caused any substantial injustice.
Substantial, my lord. Every time we come up, my lord, when we have to make arguments, my lord, and judgment is also there of division bench. So, my lord, if there is a direction from this court and that judgment is circulated to all the learned court below to follow that judgment of the division bench, because, my lord, this order was passed on 17/9/2025.
Yes, that we will do so. if-
My lord.
if it is
And
required.
my lord, kindly see, my lord, at 1 PM, my lord.
Now, you are aggrieved with what, 2,000 costs
1,000 cost also, my lord, that is
that
not
you have to
reasonable.
pay.
Because my that should not have been, my lord. At 1 PM imposing cost on the parties, at 1 PM dispensing with the cross-examination of the witnesses, my lord, bar and bench, my lord, we work in a coordination, my lord. Sometimes it may happen, my lord, 1 PM if the learned trial court start dispensing with the witnesses, starts imposing cost, my lord, at the first half itself, my lord. And my lord, in the learned trial court, my lord, in many courts, my lord, cross-examinations are taken up in the second half.
No, but there is no illegality otherwise, apart
my
from
lord, but this-
quoting wrong section.
It is not there, my lord. For that, as with regard to this section, my only prayer is, my lord, my lord, the order may be circulated to all the learned trial court below, that they will not use the wrong act now. The act which is
You
not
give
operative.
that,
I'll give, my lord, I'll give, my lord, up during the course of the day only, I'll give, my lord. আছে নেকি আপনার তাতে?
then we'll fix it in the next week on it.
I'll bring the judgment.
Okay,
Or my lord may keep after some time, I'll just get it.
not,
At 2, my lord.
not at 2.
At 3.
We'll
Otherwise,
fix it on, when is the next date fix?
Today was the date, my lord. At,
Then on Tuesday, we'll fix it. You
Right.
bring that judgment.
my lord.
otherwise, my lord, only his grievance is that PW 5 was not allowed to cross-examine and dispense with. Let him, my lord, cross-examine, otherwise, my lord,
You're also agreed with that.
My lord, I am
Only
aggrieved,
on
my
for
lord,
that,
one
my lord,
PW has been dispensed with, I am aggrieved with that, my lord. One PW, my lord, cost have been imposed, my lord, 2,000, I agree with that, my lord. And my lord, I also want that a circulation has to be made to all the learned trial courts below. That
No,
not
what is your main grievance?
yes, my lord.
My lord, my 3 grievance, my lord. I have
Which
to-
one is the prime grievance?
prime grievance, all are, my lord, 2 are prime, my lord. One is directly lordship may direct, 2 prime, my lord, PW 5, my lord, dispense with, I have to cross-examine. PW 4, 2,000 cost has been imposed, this is very unnecessary, my lord, at 1 PM imposing cost is, my lord, that has to go, my lord, this has
No,
to
that
go.
power has to be there with the court.
Yes.
Otherwise,
But my lord, at 1 PM, my lord. Had it been 3 PM, 3:34, we would have
No,
understood this first half, my lord. First, we learned trial courts, my lord, start calling the advocates, my lord. 1 PM cannot be a time, my lord. Otherwise, my lord, after 1 PM, in every case, there will be cost, my lord. We were ready to cross-examine. We have not filed any application before the court that we will not conduct the cross-examination today. My lord, at 1
then
PM imposing
at
cost, my-
what time cross-examination should be done?
my lord.
It should be, as per your submission, as per the convenience of the councils.
Councils and court, my lord. My lord, here, my lord, what happened, my lord, the court, my lord, imposing cost at 1 PM, my lord.
Okay. We'll issue notice and examine these questions. Heard. Mr. F. Hussain,
F. Khan, my lord.
sorry, F. Khan, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioner impugning the order dated 17/9/2025 passed by the Court of London Special Judge Assam in special case number 15/2023, whereby a cost of rupees 2,000 was imposed on the petitioner for deferring the cross-examination of PW4, whereas the cross-examination of PW5 was dispensed with. The learned counsel for the petitioner has further submits that the said order was passed by the trial court under section 309 within bracket 2 within bracket C of the CRPC, in spite of the fact that the Code of Criminal Procedure 1973 has already been repealed and no longer in force. Stop. The contentions raised by the petitioners need to be examined. Issue notice to the notice, he can receive notice, the PP.
Yes, ma'am. I was complete on it.
As learned public prosecutor is representing the respondents, no formal notice need to be issued to the respondents. We don't require records.
Yes, ma'am, records not.
Learned counsel for the petitioner submits that he may be granted some time to place on record a judgment of the division bench of this court, which is very relevant for consideration of the instant criminal petition. The time is allowed. Let this matter be listed at the duty. 18th of November. 18 November.
The interim, my lord, the proceedings in the land court below may be stayed, my lord.
No, why proceeding?
Then, my lord, in the meantime, my lord, the further cross-examination of DPW4 may be stayed, my lord.
When is the next date fixed?
Today was the date, next
My
date
lord,
we will get.
Only for that purpose, challenging that order, my lord, he is praying for stay of the proceeding. That is
No.
the main purpose, my lord, of filing this criminal.
No. As you like a Koran, I do. Lord, see, before the special judge, my lord, we have so many cases.
When is, before the next date is how much time the court is taking for giving next date? How much
Around-
interval?
15 to 25 days.
We'll fix this before that date,
Not
so
to be
that
fixed
no-
for next Tuesday then.
next Tuesday. 18th.
Grateful.
Twenty-five at two PM, matter will be taken up at 2 PM. We are going through some judgment.
Still you are going through.
Yes, Miller, yes, Miller. Yesterday night we have, we charged and we got some judgment, Miller, against my learned friend. Those submitted before this.
Then
At
let
2
him
PM,
go,
Miller.
let them go through properly. We will take it up.
At 2 also. At 2. It's their fail also.
Okay,
They are
okay.
competent also, very competent advocate.
No, Miller.
You are not competent.
Learned friend took time, Miller. Today we have took time, Miller, but my learned friend is objected, Miller. Previously, Miller, they took time several times, Miller. And today objected in our prayer, Miller, at morning, Miller.
So this court has to be equal to
Kindly see
both.
the order sheet, Miller, previous order sheet, Miller.
No,
Every time they took time.
Your prayer for,
Today morning we have. prayed
you
for
want
the
it to
time.
be taken up at 2. Okay, we'll take it up at 2.
All right. May it please the lordship. Lordship, this is a regular bail, lordship. We are, this petitioner is jail custody for almost 9 months, lordship. He was forwarded on to 2nd March 2025, lordship.
Charge sheeted case.
Yes, lordship, charge sheeted case. FIR on page 15, lordship. Case was registered under 64(1) BNS, lordship. After that, lordship, this petitioner was arrested on 2/3/2025, that is on forwarding report page 19, lordship. Then he has approached before this court for bail, lordship. That order, lordship, will find on page 21. Since the charge sheet was submitted, lordship, he was directed to approach before the court below for regular bail, lordship. Then, lordship, charge sheet was submitted, that is on, reflected on page 23, lordship.
When?
Charge sheet submitted page 23, lordship. It is submitted on 30/4/2025, lordship. Cited as many as, lordship, 20 witness to be examined, lordship. Then he has approached before the court below, lordship. That order, lordship, will find on page 30, lordship. His bail prayer was rejected, lordship, considering the gravity of the offense and, lordship, and witness has not been, evidence of the witness has not been started, lordship. That on page 30.
Charges are framed.
Yes, lordship. 64(1) that.
When is the next date fixed?
Lordship, thereafter, lordship, he has approached before, then against, lordship, kindly come to the page 32, lordship. Second bail prayer was also rejected, lordship.
Yes. Now whether victim has been examined.
Not
Till
examined, my lord.
3 days, lordship, till date, lordship, she has not appeared, lordship.
I- My lord, I have the strong objection, my lord, here, lordship, may kindly
No,
place
no,
the.
just a minute. Let him complete his.
Oh, my
submission.
Lordship, what happened in this case, lordship? Since, lordship, it's a session travel case, lordship. So every day, lordship, the trial as per, lordship, so far my understanding, lordship, general provision for trial and inquiry, that is reflected in 25, chapter 25, lordship, section 346. Kindly peruse that one, lordship.
Okay.
May I read that?
Yes, please read.
Power to, they have taken time, lordship, because of till date, lordship, evidence has not come up for, lordship, examination, lordship. Power to postpone and adjourn the proceedings. Suppose 1, in every inquiry or trial, the proceeding shall be continued from day to day basis until all the witness in attendance have been examined. Unless the court find the adjournment of the same beyond the following days to be necessary for reason to be recorded. Now, lordship, provided that when inquiry or trial related to offense under section 64, section 65, 66, 67, 68, 70, 71 of the BNS says, the inquiry or trial shall be completed within a period of 2 months from the date of filing of the charge sheet.
Yes. Suppose it is not completed.
Then, lordship, explanation 1, lordship. Kindly come to the explanation 1, lordship.
325.
Yes, Lord. 346, explanation 1, lordship.
Section.
346 BNS, lordship, explanation 1. If sufficient evidence has been obtained to raise a suspicion that the accused may have committed an offense, and it appear likely that further evidence may be obtained by a remand, this is a reasonable cause for remand. That is not their lordship. That reason was not explained, lordship, considering the next date, lordship.
Otherwise,
Otherwise, lordship, 9 months in jail, lordship. I may allow to lordship go out of bail, lordship, to arrange my defense, lordship. That is my plea.
what is
lordship.
the allegation against you?
Allegation is, lordship, rape, lordship.
Page 15, my lord. FIR.
Page 15, lordship.
Mhm. Let the victim be examined.
My lord. My lord,
What is
he-
your submission?
My lord, my submission is that, my lord,
When is the next date fixed?
next date is fixed on, my lord, 7/1/2026, in the month of January, my lord. Here victim, in the TIP, victim has identified the accused person. In
Heard
three,
Mr. B. Chaudhary, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Mustafizur Rahman, who has been detained behind the bars since 2/3/2025 in connection with sessions case number 270
Session
30
case number
37
37/20.
37/2025 corresponding to Mokalma PS case number 48/2025 under section 64(1) within bracket 1 of the BNS 2023. The petitioner is learned counsel for the petitioner submits that the petitioner has been detained behind the bars for more than 9 months. However, the victim has failed to appear as prosecution witness before the trial court on consecutive dates, and therefore the trial is not proceeding any further. He submits that the petitioner is ready to cooperate in the trial. He further submits that the mandate of section 346 of BNSS is that whenever offense under section 64 of BNS, whenever a case involves offense inter alia under section 64 of BNSS, the trial should be completed within a period of 2 months. However, same has not been done in this case. And therefore, he prays for allowing the petitioner to go on bail. Learned additional public prosecutor, on the other hand, vehemently opposed the grant of bail to the petitioner on the ground that the victim was raped by the present petitioner on 1/3/2025. And considering the nature of offense involved in this case, it may not be appropriate to release the petitioner at this stage of trial. Stop. I have gone through the submissions made by learned counsel for both sides. It appears that an and also peruse the materials available on record. It appears that the trial court has fixed the next date on
7/1/2026 for evidence.
7/1/2026 for evidence of prosecution side. While fixing dates in offenses involving offenses under section 64 of the BNSS, it is the statutory requirement to complete the trial as expeditiously as possible within the period prescribed by the statute. Therefore, the trial court is directed to expeditiously trial court is directed to take all necessary steps to expeditiously examine the victim girl and complete the trial as early as possible, as the trial has already exceeded beyond this period of statutory prescription, provide beyond the period prescribed in first proviso to section 346 of BNSS. Stop. However, considering the nature of accusation made against the petitioner in this case, and the nature of offense involved in this case, this court is reluctant to grant bail to the petitioner before examination of the victim girl. Hence, the prayer for bail is rejected at this stage. It is, however, the petitioner is, however, is at liberty to move the trial court seeking regular bail after examination of victim girl by the trial court.
May I pray, Lordship, let the matter be kept pending after that, Lordship, because of dispose of the matter after Lordship that.
We cannot keep bail applications now beyond 2 months. There is a Supreme Court's guideline.
Also, Lordship, statute legislators said, Lordship, it had to be completed within 2 months. And then, Lordship, remainder will be 15 days remand, Lordship, may be granted, Lordship. Here, Lordship.
Now I have issued direction.
Not up to date according to him. May I pray for fixing it on 3rd or 4th December, my lord?
Okay, Mr. A.R. A.K. Bhuya, learned counsel for the petitioner, also heard Mr. P.P. Datta, learned additional public prosecutor, who submits that though the case diary is available, same is not up to date, and prays for placing an updated case diary before this court. The prayer is allowed. Let this matter be listed on 4th of December.
Deeply obliged. Interim shall
The
continue.
interim order shall continue for next day.
Deeply obliged.
I will fix that too. I will 25.
Okay, Lordship, in this case, Lordship, my name is not there, but my senior has some personal difficulty, so he instructed me to appear.
Okay.
Yeah, in this case, that question is that, Lordship, that whether the bail, after rejection of bail prayer by the learned session judge in the case, present case, which involves offences under UAPA Act, can this 439 application, that 483 application is applicable or not?
Is maintainable.
Maintainable or
Or
not?
whether an appeal lies under
Yes.
section
that, yeah,
21.
To that aspect, Lordship may kindly first see that
Nia-
NIA Act, Lordship first.
Nia Act, some. National Investigating Agency. Yes, you read the provision.
Yes, my first submission is that when Lordship it is unlawful activities prevention act, then it is a schedule offense under that NIA Act that it will be covered. Now, whether all the provisions are covered or not, to understand that aspect.
All the offenses,
Lordship,
all the offenses under UAPA Act.
NIA Act covered, but to when Lordship, that part your Lordship will see, section 6 has clarified, Lordship will. Because the National Investigation Agency Act. So this include investigation and trial. So two parts are there. So this has to be investigated by that agency and then it will be transferred to the special court. Two things I am stressing, Lordship, because I will back by one judgment of our High Court, Lordship. So therefore I am stressing the two parts. Now first, Lordship will see section 6. Investigation of scheduled offences. 1. And receipt of information and recording thereof under section 154 of the code relating to any scheduled offence. The officer in charge of the police station shall forward the report to the state government forthwith. So he has to forward it to the state government about that intimating about that offence, Lordship. On receipt of the report under subsection 1, the state government shall forward the report to the central government as expeditiously as possible. 3. On receipt of report from the state government, the central government shall determine on the basis of information made available by the state government or received from other sources within 15 days from the date of receipt of the report, whether the offence is a scheduled offence or not. And the second part, also, whether having regard to the gravity of the offence and other relevant factors, it is a fit case to be investigated by the agency. So first, it has to be decided that whether that investigating agency, which is constituted under this act, will investigate or the state authorities will investigate.
Yes. If it is a grave offense, considering the gravity of offense.
Offense.
In
So-
addition to being a scheduled offense, the offense has to be grave.
Great. So that central government, if is of the opinion that it has to be investigated by the NIA, then it will be transferred. Otherwise, state will do.
Okay.
So first thing comes when during the investigation. And then your Lordship will see.
No, in this case is different. In this case, his plea is that the investigation was conducted by state agency.
So our High Court judgment is there, which says, Lordship, if investigation is carried out by NIA and the case is tried by in NIA special court, then bail application is not maintainable. So therefore, I am pointing out two things, Lordship, that the central government must make their call that whether this offense should be investigated by the
NIA.
agency, NIA, or by the state. If first part goes, then it will be tried by the session judge and then 439 will be applicable. Because even if
But he has cited a judgment of, you have gone through that judgment,
yes, that is of
full bench judgment of,
Madras High Court, but our High Court has already discussed.
and Madras High Court has relied upon a Supreme Court judgment.
No, that judgment I have seen, Lordship, but subject to that, therefore we have made mention in the morning hour that some accommodation. But my learned friend
No.
objected to that.
No,
Lordship. So-
regarding applicability of the apex court judgment in this case.
No, that is the Supreme Court judgment which says, Lordship, that magistrate, subject to correction, what my learned friend says, Lordship, that it was regarding extension. Order
You have
passed by
not
the
gone through
magistrate.
that judgment.
Lordship, I could not go through completely, therefore I made prayer for some time.
Then let him go through,
Friday.
because it is very important.
Because otherwise also, Lordship, that if it is tried by the.
Otherwise, what is the judgment of our High Court? Coordinate bench judgment.
Yes, coordinate bench, it says, Lordship, if it is investigated and tried by under NIA,
Only then 21 is
only
applicable,
then that bar will come.
which
Because
is,
here, Lordship, that investigation was carried out by the state.
which
that
is contrary to the full bench judgment of High Court
probably
of
that
Madras.
aspect is not considered, Lordship. This
Okay.
section 6(4).
Then you go through the apex court, let him go through the apex court judgment. Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. During the course of submission, learned counsel on the question of maintainability of this bail application, which was raised by learned additional public prosecutor on the earlier occasion, learned counsel for the petitioner submits that there is a judgment of a coordinate bench of this court, which
Division bench judgment. Lordship.
division bench.
Division bench
Then-
relied on a single coordinate bench judgment, that single bench judgment. Yeah, that division bench judgment is 2010 6 GLR 727. And that relied on a single bench
There is
judgment.
a judgment of the division bench of this court in the case of
Jayanta Kumar Ghosh and others,
Jayanta Kumar Bose and others
versus State of Assam and another.
reported in
2010 6 GLR 727.
wherein it has been observed by the court that only in case where a scheduled offense under Unlawful Activities Prevention Act is investigated by National Investigating Agency and tried by a special court, the applicability of section 21 of the said act will be there. If, on the other hand, he further submits, learned counsel for the petitioner further submits that as regards the judgment of the apex court, which was relied upon by the full bench of Madras High Court, which has been cited by learned additional public prosecutor on previous occasion, he needs some time to go through the same before he makes his submission. Considering the importance of the issue raised by learned additional public prosecutor, the prayer is allowed. Let this case be listed when? When?
On Friday, Lordship.
Friday,
Friday at 2 o'clock.
Friday কিমান আছে case? Let it be on Tuesday. On Tuesday, that is on 18th of November. Renew your pair of?
Keeping it partnered, Lordship.
Let this matter be listed
I'm obliged.
as partnered matter.
Obliged.
My pleasure. Lordship, in this case, Lordship, the impugned order passed by the Planet Court below, Lordship, and regarding one seeking Zimma of a vehicle, Lordship. And the one complaint case has been lodged in the on 26/3/2025. Kindly come to page number 23, Lordship. The petition, the vehicle owner, Lordship, and his name is not in the appear in the in the complaint, Lordship. And subsequently, Lordship, one person, Lordship, one unnecessarily was arrested along with some fake currency notes in the vehicle. And here, Lordship, in the petition, there is nothing whispering against the petitioner. And Lordship, come to for a moment, Lordship, page number 17. Page number 17. The vehicle is, Lordship, and the petitioner was hire purchased the vehicle for some financial scarcity, Lordship, and he mortgaged the vehicle in the year of 2024.
Yes, customs has anything to say.
Lordship will have to obtain instructions. According to our preliminary instructions, Your Lordship, the petitioner has given contradictory statements as regards to the vehicle. He had been saying that he had mortgaged it, Your Lordship. So there's some clarity required on the matter, Your Lordship. So we will need to obtain instructions.
Where is the impugn order?
Page number, Lordship,
21,
21, Lordship.
page 21.
An operating person, Lordship, and page number 22, first top para, Lordship, page number 22. And that is the observation of the court below, Lordship.
Where is the operating part?
Lordship, page number, first para, Lordship, page number 22, may I read, Lordship?
Yes.
I have carefully considered the submission of the both sides. The fact remains that the vehicle in question was used in the commission of a serious offense involving the counterfeit currency and a high value. The petitioner contradictory stance regarding his ownership and possession of the vehicle, and coupled with his omission to report the alleged loss or mortgage of the vehicle to law enforcement, and raised serious doubts at this stage about his entitlement of interim custody.
What contradictory stand you have taken?
As per the Lordship, and notice issued, page number 19, Lordship, kindly for a moment. And I have third time, Lordship, notice was issued to me, and I have complied, Lordship, and my statement already been recorded. So, my Lord, and I am the registered owner of the vehicle, Lordship, and I do not understand what is the contradiction of the statement to me.
Okay, let them. You'll be filing some objection.
Verbal or written, Lordship,
Okay.
will have to acquire instructions.
Heard Mr. H.R. Chaudhary,
F of Lordship.
sorry, F. Hawk, Learned Counsel for the petitioner. Also heard Miss
P.
P.
Upadhyay.
Upadhyay, Learned Counsel for Customs Department. This application under section 438,
Lordship.
then this is interlocutory order. On that day, you may raise the plea of maintainability also. Under section 438 of BNSS, impugning the order dated 14/8/2025, whereby the prayer for grant of Jimma of the seized vehicle in favor of the present petitioner was rejected by the trial court. Learned Counsel for the petitioner, Learned Counsel for the Customs Department submits that some time may be granted to the Customs Department to obtain necessary instructions in this matter, and if required, to file a written objection. The prayer is allowed. Let this matter be listed. Yes. 28.
Still earlier, Lordship. 18, Lordship.
Not,
Lordship, it pertains to Kachar district, so 28 would be ideal.
okay, 28.
Obliged.
Like-
Item 27.
Wait.
Yes.
Lordship, kindly, the order dated 24/9/2025.
24/9.
Yes. So, my learned in response to that, my lord, my learned friend has filed an objection. So I have gone through it, my lord, there is no appeal.
Co-accused
Yes, ma'am. Two of the co-accused already granted bail by your
in the
lord.
same case.
Same case, ma'am.
Where are the orders of the co-accused?
Lordship will find page 74. Annex 7.
Now, what is your case?
My lord, two person was, my lord, caught red-handed with the, my lord, suspected substance, my lord. Thereafter, my lord, this petitioner was arrested from where she was working as a, my lord, staff. So my case is that, my lord, she is no connected, my lord. On the basis of the statement of the accused, my lord, she has been arrested. My lord. And another, my lord,
What is the date of your arrest?
my lord, it is 15. Date of arrest is, my lord, on the same day, my lord. My lord, 25/1/2024. And because of delay, my lord, trial is still, my lord, in same position. PW3 is still not completed, my.
Yes. Any other ground?
So on the basis of the statement of the co-accused, my lord.
Yes.
That is, if he is complete, then I'll.
Yes, my lord, another ground is lordship already, my lord, same case, my lord. And offense is, this petitioner is better footing, my lord. Because from the position, nothing has recovered. He was arrested thereafter, my lord. And already since main accused has been granted bail by this honorable court, my lord, on the, my lord, plea of the same, my lord, I have taken.
Yes, Mr.
Lordship, it is not that he was arrested on the statement of the co-accused. She was arrested at the time of commission of the offense in possession of the heroin of commercial quantity amounting to 1589 grams of heroin. Now, your lordship, I'm very sorry to say, perhaps your lordship, in the order which has been, which actually fell from your lordship, the relevant law has not been placed before your lordship. Here, the most important aspect in this matter that has to be considered, your lordship, is section 37 of the NDPS Act. Now, what actually what I could actually gather from your lordship judgment, therein, your lordship, the petitioners as well as my learned co-counsel from the DRI, they could not actually bring up that particular objection with regards to satisfaction of the twin conditions of section 37 of the NDPS Act. Now that, as I have stated, I'll produce the judgment also to that effect, wherein a coordinate bench of this Honorable High Court has stated that that is mandatory. The section 37 has to be read into, has to be looked into, that twin conditions has to be satisfied.
Yes.
Your lordship, as also, your lordship, here, certain judgments which have been actually placed by the petitioner in that particular case, one important judgment was actually not followed, not placed before your lordship, which is the case of the, forgot the name of the case, your lordship, just. Satendra Kumar Antil versus Central Bureau of Investigation, AI 2022 SC.
Which aspect has not been?
With regards to the minimum amount of incarceration which is required in order to be considered a prolonged incarceration, so as to satisfy.
Show me that.
Yes, your lordship, I'll produce the judgment also. To the effect, your lordship. Here.
That what prolonged incarceration means.
Yes. Read in terms of section 436A of the erstwhile CRPC.
Yes.
And corresponding provision is section 479 of the BNSS. Wherein, if I could actually place, if your lordship can kindly go through section 479 of the BNSS.
Yes.
Now, if I may just read out, your lordship, section 479, where a person has during the period of investigation, inquiry or trial under this Sanhita of an offense under any law, not being an offense for which the punishment of death or life imprisonment has been specified as one of the punishments under the law, undergone detention
for a period extending up to 1/2 of the maximum period of imprisonment specified for that offense under the law, he shall be released by the court on bail. Here the language used is shall. Now, provided that where such person is a first time offender, we may consider him, the accused as a first time offender because he has not been arrested prior to this particular conviction. Provided where such person is a first time offender who has never been convicted of any offense in the past, he shall be released on bond by the court if he has undergone detention for the period extending up to 1/3 of the maximum period of the imprisonment specified for such offense under the law. Now, the petitioner, the
No,
accused.
but read the heading of that section. That says that maximum period, which
Maximum period,
it does not says that that is the limit.
1/3, at least minimum 1/3 of the
That
maximum.
maximum period means what? Make me understand the
Your
provision.
lordship, the
Maximum period means that beyond that period you cannot keep. It does not say that before that, under facts and circumstances, court cannot consider a incarceration to be prolonged
Yes, your
incarceration.
lordship. In that regard, your lordship, I place one judgment of Sahil Sharma versus Union of India. Therein, this, the courtlet bench of this honorable court, at para number 20. It's bail application number 2048/2024.
Para-
2024,
Para number?
para number 20 onwards.
No, which para you are relying?
Para 20
The
onwards.
question which you are
Yes,
pressing is that the the prolonged incarceration means
yes,
the period mentioned in section 479.
9.
No period lesser than that can be regarded as prolonged
Prolonged.
incarceration. What is there to substantiate your submission?
Your lordship, that is what, I'll just read out from para 20 onwards, so as to have an idea as to what would actually constitute this prolonged incarceration.
No, you come
Now,
directly to
directly
the,
pay para 22 then. In the case of Satyendra Kumar Antil versus Central Bureau of Investigation,
yes.
this AR 2022 SC 3386, it has been held by the Supreme Court that where under trial accused is charged with an offense under the act punishable with minimum imprisonment of 10 years and a minimum fine of rupees 1 lakh, such an under trial shall be released on bail if he has been in jail for not less than 5 years, provided he furnishes bail in the sum of rupees 1 lakh. Now, in the cases cited here in this present case also, in the cases cited, the 7 cases of Shariful Islam as Sharif, Ravi Prakash, Nitish Adhikari, Muhammad Salman Hanif Supra, Dheeraj Kumar Shukla, Anjan Nath, Chitta Vishwas. Bail was granted by the Supreme Court of India by considering the length of detention as mentioned in the state orders. However, the law laid down in the case of Satyendra Kumar Antil Supra is not found to have been diluted in any manner. Therefore, as the principles of law.
No, Satinder Kumar until nowhere says that you cannot grant, you cannot consider a period lesser than what has been mentioned to be prolonged incarceration. The judgment cited by the petitioner is that there are apex court judgment which says that if court comes to a finding that in a particular case incarceration is long enough, now on what basis court will come to a conclusion that depends upon facts and circumstances, then it overrides the embargo of section 37.
Yes.
Your submission is that prolonged incarceration fee period is first submission that it is fixed by section 479. Next submission is that
Net with 37.
that it is fixed by Satinder Kumar until.
Yes. Your lordship, Satyendra Kumar Antil was never discussed in any of these cases which had been placed before lordship in the earlier judgment, placed reliance by my learned friend.
It has been discussed.
Your lordship, Satyendra Kumar Antil was never discussed, your lordship, in the judgment which I.
No, in the judgment which are cited by the council's petitioners council.
Lordship, nowhere could be found in the judgment, your lordship. Satyendra Kumar Antil was never discussed, your lordship. Never discussed. Here, your lordship.
Okay,
if-
what is your
If I
submission?
may just complete this sentence, your lordship.
Yes, yes, please.
para 24, with utmost respect to the decisions of the Supreme Court of India in the case of Muhammad Muslim at Hussain Supra, it appears that the decision of the Supreme Court of India in the case of Satyendra Kumar Antil has not been placed. Therefore, the law as laid down in the case of Satyendra Kumar Antil is not found to have been diluted in any manner. Here, your lordship, if I may take your lordship to section 21C, under which the petitioner, the accused, has been charged, the minimum punishment which is actually prescribed under section 21C, if I may just.
No, before that, that is not disputable. Minimum punishment.
The
Your,
maximum punishment, your lordship.
your thrust of your submission is that the prolonged incarceration cannot be any period lesser than mentioned in section
479.
479 or that is mentioned in,
Earlier it was 436A, now it is 479 BNS.
that is your submission.
That is one of my submissions, your lordship. As also, here also, as per section 21C, the maximum punishment here is not less than 10 years, which may extend to 20 years, and the fine is 1 lakh rupees, up to, shall not be less than 1 lakh rupees. Same as the condition which has been laid down in Satyendra Kumar Antil. That law was never discussed in the previous judgment, your lordship. Also, your lordship, with regards to the parity, with regards to other co-accused, here, if I may draw your lordship's attention to another coordinate bench judgment, which very recent coordinate bench judgment, the case of bail application number 1918 of 2025, I just placed it before your lordship, which fell from the Honorable Justice Robin Puppan, dated 14/7/2025. Therein, if I may take your lordship from, I would just like to read out from para number 9 to 18. The relevant portion is from para number 9 to 18. Now, if I may take your lordship.
No,
para number 11.
to emphasize what point you are placing this judgment.
To emphasize that both all the accused are not on the same footing. The accused which have been.
Then parity is not meant applicable.
Here, parity is not applicable. Here, the petitioner in this case, he was the main person who was actually handling the whole consignment. He was the one who was actually receiving the consignment. These two were just drivers, your lordship.
There, what I have understood, their main contention seeking bail in this case is that they have undergone prolonged incarceration. That and they are, she has been arrested on the basis of statement of co-accused only, no other material. Those two are the submission. You counter these two
Yes,
submissions.
in our jail objection also, we have actually countered this at paragraph number 10 onwards, your lordship. If I may just read out the facts, then your lordship, just para number 6 onwards, your lordship. Para number 2, your lordship. That based on specific intelligence received on 25/1/24, the officers of DRI intercepted a Mahindra XUV 500 vehicle bearing registration number so and so with its 2 occupants and a lady. That is the accused, the petitioner, having conversation with the accused occupants of the said vehicle at the road junction near Oasis Academy, Garobosti, so and so, on 25/1 at about 800 hours. The person at the wheel of the vehicle introduced himself as Sri so and so of Imphal, Manipur, and the person sitting on the front passenger seat introduced himself as so and so, while the lady introduced herself as Srimati Kimber Khame, the accused petitioner. Now that the DRI officers informed that they have a specific intelligence that narcotic drugs are being carried in the vehicle, to which the occupants denied possessing or carrying any narcotic drugs in the vehicle. However, on repeated inquiry, Sri so and so and Sri Vaite admitted that narcotics drugs is deeply secreted in the vehicle and indicated that Srimati Kimbo Khame is the receiver of the narcotic drugs concealed in the vehicle. On confrontation with the confession of the 2 occupants of the vehicle, Ms. Srimati Kimbo Khame hesitantly admitted that she had come to receive the narcotic drugs, which would be taken out from the said vehicle at her residence, which was adjacent to Oasis Academy building in Mirapur. Now, after that, your lordship, that as the place of interception was not conducive, nor for detailed examination and rummaging of the vehicle, the DRI officers decided to take the intercepted vehicle to the office for thorough checking and rummaging. Now, if I may take your lordship to para number 10 onwards, with regards to my submission with regards to prolonged incarceration, I have stated the judgment as well as the dates and how many witnesses has been examined and everything. And thereafter, para number 11, wherein the accused under section 67 statement of the NDPS Act has admitted, has confessed in a voluntary statement that she was the receiver of the goods. What more do I need to say, Your Worship, at this stage? Pre-trial. Furthermore, she was the one who was actually in constant communication with the two accused. They are not on the same parity.
So you're relying on her statement recorded under section
Yes.
67.
Yes, section 67. In this regard, Your Lordship, that's why I want to place the judgment of the coordinate bench of the in Sahib Sahani bail application number 1918 of 2025 dated 14/7/2025, wherein this honorable court if Your Lordship may kindly peruse to para number 12. It is now well settled that parity can be a relevant factor, but cannot be the sole ground for granting bail. The court has to consider specific facts and circumstances of each case, including the role of the accused, the nature and severity of the
No,
charge.
that is agree, I am agreeing to that submission.
Your Lordship. Also, here in this judgment, para number 15, Your Lordship. Moreover, it is to be noted that the quantity of ganja recovered from the possession of the accused are of commercial quantity. And as such, the accused has to satisfy the twin requirements of section 37 of the NDPS Act that he is not guilty of the offense and he will not commit any offense while on bail as held by the Honorable Supreme Court in the case of Ajay Kumar so-and-so at Pappu. Thereafter, this Honorable Court denied the bail application and dismissed the case, Your Lordship. Because considering the gravity of the offense as well as the impact upon the society, which is a commercial quantity of 1589 grams of heroin. So section 37, Your Lordship, was never looked into or never placed before Your Lordship to be considered prior to considering whether or not the provisions, mandatory provisions of section 479 of the BNSS read with section 37B of the NDPS Act has been complied with or not. So that's why in my humble respectful submission, this aspect was left out in the previous judgment. Also, very recently, Your Lordship, in the case of State of Karnataka versus Darshan, if I may just place one particular paragraph of that judgment, para 20.4.6, wherein the Honorable Supreme Court said that whether or not the delay as such which would actually 20.4.6, page number 27, internal page number 27 of the judgment. The existence of a long list of witnesses and the examination would not actually be a valid reason to dilute the gravity of the offense or to disregard the case put forward by the prosecution. Here, although I admit that the number of prosecution witnesses is 9 and so far only 3 has been examined, but that would actually not give them a leeway to deal with such a heinous offense of trafficking in contraband items of heroin of 1589 grams of commercial quantity.
What is the maximum punishment? 21C?
20 years.
20 years.
20
So your submission is that before 10 years, they cannot be
No.
released.
I give that concession that since she has not been arrested earlier, I don't have the information whether she has been arrested or not. But since she has not been arrested
7
earlier,
years.
7 years, Your Lordship. At least before 7 years, as per 479, she cannot be released on bail. being the main.
On the ground of prolonged incarceration.
On the ground of prolonged incarceration.
Okay.
That is my humble submission, Your Lordship.
Heard Mr. G. Uddin, learned counsel for the petitioner. I have to reserve the order. Also heard Mr. D. Bora, learned standing counsel DRI. You have not preferred appeal otherwise.
No, Your Lordship.
Who submits that though the DRI has not preferred any appeal against the grant of bail to the co-accused persons who were enlarged on bail earlier on the ground of, mainly on the ground of prolonged incarceration. However, he makes submission to the effect that by citing judgments in support of his submission that the period of prolonged incarceration in a offense involving commercial quantity of contraband under no circumstances may be the maximum period, maybe the period which has been mentioned in section 479 of BNSS 2023, on completion of which the accused may be granted bail. Stop. Let this matter be listed for delivery of orders today's. On 19th of November.
Highly obliged.
Petition will be elected.
It is behind the bar, let's say 125 days, let's say. Yes,
Yes, you have anything to say?
I am appealing on behalf of the informant. Today I have received the additional copy of the additional agreement. We have objection, we will file written objection. In this case, so I need.
otherwise, does it come to additional affidavit? It is like serious condition, he's hospitalized. He's on ICU,
Who has
it is not.
he is behind the bars.
Plus,
He is under medical treatment.
he's hospitalized, 125 days is already behind the bar. Consider
Wha-
case,
What ailment he is suffering from?
let's say, page 30, additional affidavit, let's say. Page 37,
What is the ailment?
brain stroke.
Oh, brain stroke.
Humerus found mid-brain of the petitioner, let's see. 50% paralysis also. Here is a CT scan report, let's see. Page 37.
How much time will you take? Or
On Tuesday,
let them file objection. We'll take it up on Tuesday. Heard Mr. L. Gogoi, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, as well as Mr.
P. New.
P. Neog, appearing for respondent number 2, who submits that he has received the copy of bail application today only and prays for some time so that they may, that the respondent number 2 may file an written objection against the prayer for bail. The prayer is allowed. Let this matter be listed on Tuesday. Tuesday, that is 18th of November. Name of Mr. P. Neog be reflected as engaged counsel for respondent number 2 in the cause list henceforth.
Item 29.
Lordship, this such serious matter and petitioner is behind the bar for 122 days. The LCR has been received. Lordship.
What is the matter?
My lord, as per official, my lord, service report awaited, my lord, POCSO matter.
POCSO matter. You find out,
My lord.
heard Mr. A.B.T. Hawk. B.
E. Kumar.
B. Gohai.
Kumar.
Kumar, my lord.
B. Kumar, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. As for office note dated 30/10/2025, service report in respect of notice issued to respondent number 2 is still awaited. So learned additional public prosecutor is requested to take information regarding fate of the notice issued to respondent number 2
My lord.
from the officer in charge of concerned police station and let this court know about the same on the next date fixed. Let this matter be listed on shorter date. 19th of November.
Item 31.
May I brief your lordship?
Yes.
My lord, here, she did not receive, my lord. Lordship may kindly pay the office note, my lord, last office note, my lord. They are granted, my lord, some protection, my lord, interim protection, my lord, for medical purpose, my lord. And thereafter, they have to surrender before the court, my lord. Lordship may office note. For that reason, they will have to file one, my lord, affidavit, my lord.
You have surrendered. You have
Whether-
surrendered before.
Whether
Then-
surrendered or not, my lord.
Then you
they
have to file an affidavit.
The, my lord, bill condition, my lord, condition number 1, 1 and 2, my lord.
Where are you now? Behind the bars? They were granted interim bail.
Only for the operation, my lord, operations purpose, my lord.
And on 7/11, you
Have to surrender, my lord.
have to, you were required to be before the Court of Learned Chief Judiciary. Have you surrendered or not? Where are you now? In jail? Then if you have
My
surrendered,
lord, then
find out. Take instruction. You are unable to say anything. You take instruction and let this court know. We'll take it up after some time.
within the code, my lord. Order. What do you can surrender?
You take instructions and let this court know whether the petitioner has surrendered and whether he is in jail or not. Find out and let this. None has appeared. Mr. Paul. None has appeared for Kesari is there
Not receive, my lord, she did not receive.
for the petitioner on call. The case diary has not been received. Learned additional public prosecutor prays for some time for production of the case diary. Prayer is allowed. Let this case be listed again on
25, my lord.
25 November.
33. Officer reveals that receipt the TCR has not been received yet.
Heard Mr. B. Haldar. The notice,
Notice also service report also awaited.
heard Mr. B. Haldar, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. It appears from the office note that scanned copy of the trial court record has not been received. Issue reminder for the same. Learned, it also appears that nothing has been stated in the office note regarding service of notice on respondent number 2. No. Have you taken steps?
Clerk has taken a step. We have only just have to submit the copy of the petition in the office of the public prosecutor. And thereafter, the subsequently they would take steps to office of the public prosecutor. We have submitted. Whether they have submitted before the registry, you will have to first submit before registry.
There is
You
no,
come to the registry. There is no office note to the period. That is why I am also confused.
if there is no office note, if you have not taken steps, then this bail application is liable to be dismissed.
No, sir, I have already taken step.
Show something.
The copy is not with me. I prepare.
You have to take steps as per the notification number 17.
My-
Detailed notification of the registry is there, how to take steps.
If on the first occasion, Lordship, the direction was given to the office of the public prosecutor to serve the copy.
No,
of the
that is the procedure prescribed in the notification issued by the registry.
Uh,
You take steps, otherwise you take fresh steps. Otherwise, this bail application will be dismissed.
Regulate counsel for the.
Notification,
Notification.
Total. POCSO notification.
As per Deepak Nayak also, my lord, it is reveals.
No, as per that, a notification
My
of the
lord,
registry
they are
has.
the-
It appears that there is no notification, no office note regarding taking of steps for issuance of notice upon the respondent number 2 by the petitioner. Stop. The petitioner is directed to take fresh steps within 3 days from the date of this order for issuance of notification, issuance of notice on respondent number 2 in pursuant to the provisions laid down in the notification number 17 dated 15th March 2025, 24 issued by registry of this court in this regard. Stop. List this matter again on 28th of November. Show name of Mr. R.C. Paul in earlier case. What is the item number?
Item number 32, my lord.
32.
32, my lord.
We have passed the orders.
CD concourse. CD. 34 earlier call. Any date?
You go through the order.
Please, your lord. Scan copy of DCR was called.
Agor case to the RC, Mr. R.C. Paul. A Paul attendance to the kind. Yes,
Scan copy of DCR was called for. also.
whether it has arrived or not.
My lord, if they are not received, my lord, here service report also awaited, my lord.
Heard Mr. What is your name? M. Ahmed, learned counsel for the petitioner. On perusal of the office note dated 10/11/2025, it appears that scan copy of the trial court records has not yet been received. Stop, issue reminder for the same. It also appears that service report in respect of notice issued to respondent number 2 has not been received. Stop. The learned additional public prosecutor is requested to take the information regarding fate of the notice issued to respondent number 2 and from the officer in charge of the concerned police
Right.
station and let this court know about the same
Right.
on the next date fixed. Let this matter be listed again on, 28th of November,
Lordship, can it be on 25th?
25th of November.
Lordship, I have a humble submission. The PCR should actually maybe come from the POXO code, special POXO code, Kamrup Metro.
Earlier from which it was.
So they have CBS. The case is pending in the Honorable Court of POXO, Kamrup Metro. Guwahati.
Agar case to issue reminder for requisitioning of the trial court record from the concerned trial court, that is Court of Learning,
Special Judge. POXO,
Special Judge Poxo, Kamrup Metro.
Deeply obliged.
Item 35.
May it please your lordship, as per office noted lordship, 10/11/25. Service report of respondent number 2 is awaited lordship.
My lord, here we have received a case diary, my lord. But service report is awaited, it is POXO 6, my lord.
POXO 6.
You take
My lord.
information.
I have already.
Heard
information was-
Miss S. J. Ghosh, learned counsel for the petitioner. Also heard Mr. B. Sharma, and the additional public prosecutor. It appears from office note dated 10/11/2025 that service report in respect of notice issued to respondent number 2 is awaited. Stop. Learned additional public prosecutor is requested to take information regarding fate of the notice issued to respondent number 2 from the officer in charge of concerned police station and let this court know about the same on the next date fixed. Let this matter be listed on 27th of November.
My lord, CDB written till.
The case diary which is available before this court shall be retained till next day.
My lord.
Obliged.
31.
Is it? Evidence?
Evidence here nahi hospital.
People is it? People is it?
Yes,
My lord, in this case, my lord, he is admitted in the hospital, my lord. Some documents are available with me, my lord.
have you surrendered?
Not yet surrendered, my lord.
But that was the condition.
Condition, first
Yes,
condition.
condition was there, my lord.
Then
But
you
thing
have
is
to
that after
approach this court for
For extension also.
modification of the conditions.
Thing is that today his treatment is undergoing treatment.
No, once you get bail, you cannot change your stand.
Right.
You have to approach this court
There
by
are some-
filing.
Yes, my lord, there are some other cases of the same accused, my lord. Those matters listed on 26, my lord. This matter may also be. my lord.
Not the matter, my lord, whether it is fixed on 26 or not. my lord, but
There are some other cases.
Yes,
Then,
but
then
evidence-
we'll vacate the interim order.
They will have to file affidavit, my lord. Today is the, my lord,
That was the
condition. my lord.
condition that you have to file an affidavit.
Affidavit definitely will file after releasing from hospital,
Not
my
the
lord.
condition. it is.
Now he is in hospital, my lord. There are
You have
some,
not taken any steps.
after releasing from jail, my lord. You are suffering from some other disease.
Now you will continue to suffer from many diseases
Oh, my
once you are in
After
bail.
That's why, my
releasing
lord,
from the bail.
That's why, my lord, now yesterday he.
We are
admitted in the
vacating the interim order. You have to comply with the order of the court. If you fail to comply, you have to approach the trial court, approach the court with proper justification for modification of the condition if necessary.
My lord, there are some other cases also pending, my lord. Those matters have been listed on 26. This matter may also be, my lord. 26. My lord, 11, my lord. Kindly, my lord. Now he is in hospital, my lord. His treatment, my lord, operation is going on, my lord, today, my lord. After
should be-
releasing my lord, we will file the.
That should be
affidavit, my lord.
informed to the my lord, court below or my lord, that at the time of
There are some
surrender or at
documents
the
are
for the
available,
court
my
below,
lord.
my lord. But
Some
not
documents
informed, my
are
lord.
available, my lord.
Affidavit also
Kindly
not
peruse, my
submitted,
lord.
my lord.
Heard Mr.
On
T.
20
Hussain,
2611, my lord.
learned counsel for the petitioner, who submits that the petitioner could not comply with the conditions attached to the interim attached while granting interim bail to him by order dated 15/10/2025, as he is still undergoing, he is still admitted in hospital. In which hospital?
Arya Hospital, my lord.
Mm.
Arya Hospital.
In hospital. And learned counsel for the petitioner further submits that this matter may be fixed on 26/11 so that appropriate steps in this regard may be taken. On the other hand, learned additional public prosecutor submits that since the interim bail was granted to the petitioner on 15/10/2025, subject to certain conditions, and since those conditions are not fulfilled, the interim bail is liable to be cancelled. So. CD is there.
CD not present.
Learned additional public prosecutor further submits that case diary is also not available and seeks some time for production of the case diary. Considering the submissions made by learned counsel for both sides, let this matter be listed. Let the reminder be issued for case diary. Let this matter be listed on 26/11/2025. On that day, we'll see.
Leave level, leave level.
I can 56 for supplementary.
May I please tell you? কি হলো? Lordship,
Kiman,
main-
56.
Yes,
Yes.
my lord, I have gone through the, my lord, LCR, my lord. There, my lord, I didn't get, my lord, that is the direct implications lie from, my lord, independent witness, his name. And during the course of TIP also, my lord, he was not identified, my lord. Another person was identified, Monbarua. But my lord, in the, my lord, 47 notice, my lord, and the 48 notice, my lord. There's one clause is there where it is stated that, my lord, that is the based on the, my lord, there is the video footage, my lord. Their involvement is found. That is in the, my lord, 47 and 48. Apart from that, my lord, from the witnesses, my lord, we are not getting.
Video footage, whether
lord.
video footage is available.
My lord, footage is not available with us, my lord.
No,
But that is in the, during the course of, my lord, there is 147 and 48 notice, my lord.
No, no.
In the record, my lord, I have flagged, my lord.
In the 47 sound record. Before mentioning something in the 47 notice,
My lord,
that finding has to be there in the case diary.
my lord,
There has to be some endorsement in the case diary by the IO
my lord,
that on going through the video footage,
my lord.
I found so and so person
That-
there,
that,
and
my lord,
therefore he
because,
is
my lord, entire, my lord, there is a series, all parts are not available. That I yesterday also, my lord, made my submission, my lord. But regarding that part, my lord, in 47 and 48, my lord, two clauses are very, my lord, categorically stated, my lord. My lord, may kindly peruse that, my lord. Because after.
No,
his-
but we cannot go by 47 and
Yes, my lord,
48.
that's also, my lord. That is all.
There has to be something in the case diary.
Yes. Okay.
203 days lordship behind the bar. We are young with local and
You
private.
speak to IO over telephone.
My lord,
This is a charge sheeted case.
that is the case, my lord. Or my lord, another maybe only I will make my submission, 5 minutes. Again, one, I just to give you a look. Already I have gone through that. I didn't get my.
That video footage has been,
My lord, regarding that and endorsement or entry in the city, that on the basis of the video footage, they are arrested. Only that part, my
and
lord, is-
whether that video footage has been made,
my lord, that is in
eh,
the part of the search sheet. In the search sheet, my lord, the word video footage is there, man. Video footage is also, my lord, submitted before the.
video footage is submitted.
Yes, my lord, that is submitted. That part, my lord, I have gone through, man. In the search sheet also, my lord, I have flag mark, my lord, on that relevant portion, my lord. There, my lord, the video footage and also, my lord, the TIP part, all parts are there in the search sheet,
Then go through the case diary,
my lord.
that what is there in the video footage.
Yes, my lord. In the entry, my lord, in endorsement, if
In-
something is
There
there,
must be
elaborate
that it
description.
is
my
seen
lord.
from the video footage that
Footage
he is
that
hitting
He is also there in.
or he is merely present.
Yes,
That
that
endorsement is,
only that part. But it's within, my lord, 5 minutes, because I have already gone, I know where is the places. Within 5 minutes.
we'll take it up after some time.
One interim matter, and I have checked the record matter. Service was awaited. Later, final PP said they have completed the service.
My lord, here we have received the, my lord, service report, my lord. So it's me appoint amicus curiae.
Heard Mr. D. Bora, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that the notice issued to respondent number 2 has been duly served.
My lord.
Stop, since no one has appeared on behalf of respondent number 2, this court is inclined to appoint one amicus curiae to defend the cause of respondent number 2 in this case. Any amicus present in the court? Release them. Accordingly, this court is accordingly, Miss Manisha Karen Brown, learned counsel whose name appears in list of amicus curiae prepared by the registry, is hereby appointed as a amicus curiae to defend the cause of respondent number 2. The petitioner is directed to furnish copy of bail application along with the annexures to the newly appointed amicus curiae within 2 days from the date of this order. The registry is directed to reflect the name of Miss M.K. Brown as amicus curiae in the cause list henceforth. Let this matter be listed on 26th,
My lord.
First week of December.
first week of December, on 4th
My
of
lord. We will
4th
have
of
to
December.
retain CD, my lord, then CD received, my lord.
4th of December.
Fine.
CD received, why such a long date?
Newly
Short
appointed.
date.
My lord.
Then my lord can be on
26th.
28th, my lord.
No. Let it be on 25th of,
Then 27, my lord, kindly. my lord,
why?
27. Thursday, my lord.
You are behind the bars.
Yes, my lord.
Why you are,
No,
Not the end.
I'm on interim.
therefore,
No, my lord. Can be on 27th. as well.
27th of case diary may be retained till
Retained.
next date.
38th of this.
What we need to tell box is
38 minutes scan copy received. I tried to, my lord, get the instruction regarding service of notice, but my lord, till now I have not yet received any.
You take the instructions.
Yes.
Within. Heard Mr. A. Mubarak, learned counsel for the petitioner. Also heard Mr. P. Botakur, learned additional public prosecutor, who submits that he could not contact the officer in charge of,
Yes, my lord. I contacted, but my lord, till now.
though he contacted the officer in charge of concerned police station. However, till now, he has not been intimated about the fate of the notice issued to respondent number 2 by the said officer. He therefore seeks some more time to let this court know about the fate of the notice issued to respondent number 2. The prayer is allowed. Oh, when?
On, my lord, 1911.
Let this matter be listed on 19th of November.
Nine, my lord, case diary received, my lord, petitioners are in interim, my lord, but their statement is not available in the case diary. I will have to, my lord,
You have appeared.
take instruction, my lord.
No. When you were granted interim bail,
Interim granted on, my lord, 20.
this matter was disposed of earlier. By who is the petitioner?
Biswajit Saikia, my lord, and one, two petitioners, my lord, Biswajit Saikia and one Purna Bodoli.
Itu বেলেগ কত 2152
No, my lord, this is AB 249,
2152 order itu.
item number 39.
Heard, Mr. What is your name?
Vicky Bora.
V.K. Barua, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned additional public prosecutor, who has submitted that though the case diary is available, however, he seeks some time to go through the same.
Well, I have gone through the case
However,
diary.
he submits that there is nothing to indicate therein as to whether the petitioners appeared before the investigating officer in pursuant to the order dated 23/10/2025 or not. On this, learned counsel for the petitioner seeks time to get the instruction. The prayer is allowed. Let this matter be listed again on 18th. You take instructions. 18th.
40, my lord.
Wait, please, your lordship.
40, my lord,
CD
CD
was
not,
called for.
CD not received, my lord.
Not received yet.
Heard, Mr.
S.A. was,
S. What is your name?
S.A. Wasi.
S.A. Wasi, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned additional public prosecutor, who prays for some more time for production of the case diary. Prayer is allowed. Let this matter be listed when
On, my lord, 25/11, my lord.
25/11.
What's your lordship? No, implement.
We are taking up 41 first.
It's an application 408 is for improvement of the applicants. In fact, the impugned order, which is under challenge, that was passed by the trial court on the basis of the application filed by us, but we have not been made a party. So I'm praying for the impeachment
Party in which case?
in the present revision criminal petition. 649.
649. Putul,
Item number 41.
criminal petition. Yes, what is your submission?
I have filed an application before the trial court to allow me to participate in the proceeding.
Who are you?
I'm the complainant, my lord. I have submitted an application before the labor authorities for, my lord, alleging contravention of the award passed by the, my lord, the labor board, my lord, in a reference case. So that was, my lord, after, my lord, making necessary, my lord, inspection, etc., my lord, a complaint has been filed by the labor authority before the, my lord, magistrate as per the, my lord, Industrial Tribunal Act, section 29. And in that complaint case, I have made an application to allow me to participate in the proceeding, and that was allowed by order dated 22/4/2019, which is under challenge before this honorable court by the petitioners.
That order of impleading you as party before the labor court has been is under challenge.
My lord, for non-implementation of the award, for violation of the my lord, various provision of the, my lord, Industrial Tribunal Act, a complaint was filed by the labor authority, labor inspector before the, my lord, trial court, as per section 29 and 34. And complaint has been registered. As I am an interested party, award was in my favor. So therefore, I have filed an application to allow me to participate in the proceeding. And accordingly, my lord, the court, my lord, by order dated 22/4/2019, at page 163, court had allowed my prayer. Now that is
Page 163 of the criminal petition.
lordship. One 64 minutes, let's say may come to third, last paragraph. The learned additional public has not raised any objection to the fact that petitioner want to assist him in conducting the case. Hence, I hereby allow the aforesaid 23 numbers of petitioners, that is present applicants, represented by the.
No, you are not impleted. You were only allowed to assist the PP.
So this order is under challenge. So I am seeking implement in this petition because that was.
This
passed-
order to assist the PP is under challenge.
Yes. And it was passed on the basis of my application under section 321, 322. Yes.
Okay. You have any objection?
I have any objection means lordship, we have come for setting aside of a complaint case, which was lodged by S. Chakraborty, Assistant Labor Commissioner against BMC.
You are not impugning this order dated 22/4/2019.
The prayer is at page 25.
In the criminal petition,
Yes, page 26, 25 of the
26.
prayers.
Two orders, 22/4/2019 and 31/5 as well as the proceedings. Whole proceedings we are challenging.
So this order 22/4/2019 is the order, by which we were allowed to assist.
yes, what is your objection?
Basically, they are not party in that case in which they were allowed to assist the proceedings before the CGM.
Yes.
That whole proceeding is under challenge here. So I leave it to this honorable court, but it was also in the understanding when the previous council, they were agreeing that the whole case may be heard instead of imprisonment.
But-
I'm permitted to, submit.
Parties,
Yes, that because when MS Borgohain, unfortunately, he is no more with us. So he was under understanding that whole case may be heard, and that is why on 2 or 3 days, the case was at the stage of hearing also.
no, but they are not impleaded as party in the main criminal petition.
So I leave it to this honorable court.
Then we'll allow them and hear the entire case.
This is the, no, this is the central government council, because central.
Who is the
government-
other side?
Yes, because the central, they have lost the case against us. they were assisting them in the CGM. Here also, they
He
can
may.
assist.
Yes,
I have
he
no
may.
objection to that.
How a senior counsel will assist?
That call he will have to take.
Here, simple, my lord, the order which has been passed on my application.
He has to be assisted. He is to be assisted.
That understanding they can have, internal understanding.
That will make my party and fix the.
No, Making a party again, it will create the confusion. Because they are not allowed to be a party in the court below also.
Yes.
My ground is that, my lord, the order which is in my favor, that has been impugned here. At least in this petition, I should be a party to protect my right in that man. Had I been made a party, perhaps the stay order would not have been granted because this petition itself is not maintained.
Rather, the criminal petition would have been dismissed.
Yes.
If the whole case is criminal, whole proceedings would have been set aside. Because this case cannot be lodged against us because there are several observations of the High Court and the Supreme Court that the order against whom the contempt case has been lodged, it has been already complied with.
In IA.
Their contempt case also were dismissed earlier. Only on the last occasion, Lordship, lower court's record were called for, no? And for that purpose, the matter got delayed on the last occasion.
Now whether the courts are,
LCR has come on.
there are other connected matters. In all the matters, issue is same,
Same issue.
Yes, same. And my application for implement in both.
separate applications.
That has been kept pending because it was under the understanding that the whole case will be heard. I can give the whole chart of the dates. If Lordship is pleased to look at the order of 22/8/2024 onwards.
Now whether today you want to be hearing,
Today it will be too late, Lord.
yes, it will take some time.
So he can always assist because that was the understanding. And if he wants, if he is satisfied that it's implement, but that will not make any effect in the proceedings below.
That is there.
With that observation, I have no objection.
Here, my lord, I have to protect my, my lord, order.
They are allowed to participate in the present hearing as a party, but that will not entitle them to be a party in the proceedings in the court below.
Okay. Heard. Mr. G. Soikia. This is item number?
41.
I am appearing in all the
Sorry,
three
heard
matters.
Mr. P.J. Soikia, learned senior counsel, assisted by Miss K. Barua, learned counsel for the applicant. Also heard Mr. D. Soikia, learned senior counsel, assisted by Mr. N. Singh, learned counsel for respondent number
It will be one.
How many petitioners are there?
I think it's from respondent opposite party number 4 to 22.
No, you have not made them a party in the interlocutory application. Whom you are representing? Mr. Soikia. The Union of India.
No, I'm for the ONGC, the three officers
Yeah,
individually.
you have not made them party in the,
Page 5. Page 5. Below, my lord, down below. Versus Rajnikant, Union of India, Chief Labor Commissioner. Western Labor.
Three of the ONGC officials. are-
Rajnikant is the.
Rajnikant. One. In the IA, I'm one, and the 2 and 3, 3 and 2, 3, 4 are the central government.
appearing for respondent number 1, as well as Mr. B. Sharma, Central Government Council, appearing for respondent number 2, 3, and 4. This interlocutory application has been filed by the petitioners, praying for impleading them as respondents in the connected criminal petition number as one of the relief sought for in the said criminal petition is, where is the impugned order?
At page 163.
Is order dated 22/4/2019. One of the is setting aside of order dated 22/4/2019 passed in CR case number 4402C/2009, whereby the present petitioners were allowed to assist the additional public prosecutor before the trial court. Stop. Learned on this, the learned. Stop. Learned senior counsel for the respondent number 1, Mr. D. Kalkas, submits that he has no objection if the present petitioners are made party in this, in the connected criminal petition, subject to the condition that same shall not affect their status in the, before the trial court. Stop. In view of the submissions made by learned counsel for both sides, the present applicants are allowed to be. You have to file an amended cost title.
We have to do it.
You have to do it. Allowed to be impleaded as.
They will be at a cost.
No. Allowed to be impleaded as respondent in this, in the connected criminal petition. The petitioner shall file an amended cost title in the connected criminal petition before the next date fixed. Since the trial court records are before this court, endeavor shall be made to finally hear the matter on the next date fixed. Choose a date.
9th of December, if it is not.
Let this matter be listed on 9th of December. Similar orders.
Regard to the item number, the 57 and 58.
57 and 58 separate order, similar line of, similar orders in item number 57 and.
There was an interim order that may continue, Lordship. The proceeding was stayed.
The interim order shall continue in till next date.
Highly obliged.
The interlocutory applications are disposed of. think.
Your lordship. Lordship, step to taken, your lordship. But, your lordship, we have learned that, your lordship, the response has changed her address, your lordship. And we are unaware of her address, except a mobile phone number, we don't have anything, your lordship, now.
What is this case?
Your lordship, it was regarding a dishonor of check case, your lordship, where, the appellate court has turned down the order judgment of the, trial court, your lordship, and thereafter, we are before this court by filing this revision petition, your lordship. Now, your lordship, the order has been suspended by this court, your lordship, but, your lordship, notice couldn't be perhaps served, your lordship, because, the respondent has changed her address, your lordship.
Now what is to be done?
Can it be served through alternate method, your lordship?
By publication?
Publication, your lordship, when BNSS suggests, sending, notice through electronic form, your lordship, that can also be done.
Electronic mode, where are the rules?
There
Not-
are provisions in the
Come,
BNSS.
come prepared. Not now. Come prepared. And try to find out the alternative address. Either you come prepared with the submissions. Heard Mr. I.A. Hussain, learned counsel for the petitioner. Also, heard state is a party.
Yes, sir.
Also heard Mr. B. Sharma, learned additional public prosecutor. It appears from the office note dated 27/8/2025 that the notice has been received back, that the notice issued to respondent number 2, that the AD card issued to respondent number 2 has been received back with illegible signatures of the recipient thereon. Stop. In view of the above, the registry is directed to place the postal track consignment report of the notices issued through registered post to the respondent number 2 on the next date fixed. Let us see the postal track. Let this case be listed on 19th of November.
Right.
Need trigger lordship. Okay, as per office note dated 10/11/25 lordship, neither AD card nor answer notice upon the sole respondent lordship. Matter relates to arising out of a petition filed by 127 whereby the maintenance was enhanced. And my explanation will also let the tax concern report be placed before this honorable court, or the registry may verify the tax concern report, because on last occasion when the respondent appeared before the learned family court to receive the maintenance amount, she verbally told that she have got the notice,
Okay, okay.
but that was told to me by the petitioner. So lordship, the tax concern report may be placed on record.
Okay. Heard Mr. S. N. Krishnathraya, learned counsel for the petitioner. On perusal of the office note dated 10/11/2025, it appears that service report in respect of the notice is issued to the respondent, the sole respondent, has not been received back. Stop. The registry is directed to place the postal track consignment report in respect of the notices issued to respondent by registered post with AD on the next date fixed.
Interim order is there, lordship.
Yes. The let this case be listed on 26th of November. 26th of November. The interim order shall continue till next day.
My lord, here I pay for short accommodation, my lord, regarding the service, my lord. Today morning also I have informed to our office, my lord, regarding the service, my lord, and it was also sent to the, my lord, officer in charge, my lord. Officer in charge, Golokganj, my lord.
It is fourth occasion, my lord.
Heard Mr. P.K. Deka, learned counsel for the petitioner. Learned. Also heard Mr. B. Sharma, learned additional public prosecutor, who prays for some more time to let this court know about the fate of the notice issued to respondent number 2 after taking necessary instructions from the officer in charge of concerned police station. The prayer is allowed. When?
17, my lord, 1 second.
Let this matter be listed on
For the list.
17th
Last
November.
minute.
45.
There is a delay of 30 days in preparing the present appeal.
Appeal,
Appeal,
how many days?
30,
1-3.
30.
Why?
So, initially, he was basically due to his financial status.
Yes, Mr. Sharma. Any objection?
My lord, whether he is properly explained the delay, my lord. That is the, my lord, first of all, yes, my
From
lord.
paragraph 2, 3 and 4.
Financial condition may not be one of the sufficient ground, my lord.
Sometime it may be.
My lord, sometimes maybe, sometimes not, my lord.
No, he is a lordship carpenter, and that too in a remote village, lordship.
Now you are behind the bars.
He is on bail.
Given the conviction. Section 8, POCSO, my lord.
You are on bail.
Yes.
3 years conviction.
How much delay? 30 days. Heard. Mr. J. Datta.
You.
Sorry, you Datta. Learned counsel for the applicant. Also heard Mr. B. Sharma, learned additional public prosecutor. This interlocutory application has been filed under section 5 of the Limitation Act. Praying for condonation of the delay of 30 days in preferring the connected appeal, wherein the judgment and order dated 3/7/2025 passed by the learned Special Judge POCSO Dhemaji in Special POCSO case number 26/2017 has been impugned. Learned counsel for the petitioner has submitted that the petitioner is a carpenter by profession and due to financial constraint, he could not prefer the connected appeal within the prescribed period of limitation. He has stated that the grounds for the delay has been elaborately explained by the petitioner in paragraph number 4 of the
2 to 4.
2 to 4 of the condonation of delay application. Learned additional public prosecutor objected to the prayer of condoning the delay.
Only on the ground of financial condition, my lord, as there is the provision of legal aid counsel, legal aid.
On the
Sorry.
ground that the plea of financial constraint may not be regarded as a sufficient ground for condoning the delay in preferring the connected appeal as the applicant, even if has financial difficulties, could have availed the free legal aid services provided by Legal Service Authority. Stop. I have considered the submissions made by learned counsel for both sides. Stop. Though the objections raised by the petitioner, by the learned additional public prosecutor has some force in it. However, considering the grounds stated in paragraph number 3 to 6 of the application for condonation of delay to be sufficient ground which prevented the petitioner in filing the connected criminal appeal within the prescribed period of limitation, this court is inclined to condone the delay of 30 days. Accordingly, same is done. The registry is directed to register the connected criminal appeal and list the same for admission after a week on a date to be fixed by it. This interlocutory application is accordingly disposed of.
Ablaye.
Wait, Your Lordship. I saw combination of delay of 54 days, Your Lordship. Same grounds, Your Lordship, financial constraints, Your Lordship,
Same
from
grounds.
paragraph 2 to 5.
Amita. एक और डिक्टेशन ले लीजिए.
As per the registry, it is 54, but as from data knowledge, it is 27 days, Your Lordship.
Same order, 54 days. Instead of carpenter, what do you do?
Simple electrician, Your Lordship, that too per day.
Instead of carpenter,
day work.
electrician.
Electricity.
Delay is 54 days instead of 30 days. Proxometer,
No, Your Lordship, maintenance, Your Lordship. In filing the criminal revision petition, Your Lordship.
carpenter. And case
Electrician, Your Lordship.
case यहाँ से देख लेना. Allowed.
Much obliged, Your Lordship. Thank you.
May I please, Your Lordship? We have taken step against the respondent number 2, Lordship. And as per the office note, the service report of the same is awaited, Lordship.
What is to be done? What is to be done? We should await or you will take fresh steps. Okay. Third, Miss, what is your name? P. Dekar, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. On perusal of the office note dated 10/11/2025, it appears that the notices issued to respondent number 2 in respect of the by speed post has not yet been received. Stop. The registry is directed to place the track consignment report of the notices issued to respondent number 2 by speed post on the next date fixed. Let this matter be listed on 26 November 2020.
Deeply obliged.
Wait, please. Which in this matter, Kezair was called from the Bokajan PS.
Is there?
If I may indicate one order of this on Lordship's order, Lordship, that is 15/12/2023. Lordship, that was a positive direction of this court to 15/12/2023. Since then, Lordship, this matter.
15/12/2023.
20?
3.
Lordship, since then, Lordship, the case that has been called. And that is a
It has
positive
not-
direction.
My lord, it is not, although he submitted, my lord, CD was called for, it was, listed after a long time, my lord. One after one day, my lord, it is long time, my lord. Whatever maybe, my lord, I will put in the case in the next date, my lord.
We'll fix, give a fee.
My lord.
Earlier also a fixed date was given.
Lotships.
What is your case?
But
Washing.
similar offense, Lordship, similar offense, I had got an acquittal, that affidavit I have brought up, Lordship, from the Johrat PS, Lordship. Similar facts, was a similar offense. I was again come.
Mr. Sharma, you take steps.
My lord, then he is involved in several cases, my lord, in several.
No, no, we need the case diary.
My lord,
If case diary is,
my lord. Bokajan 78, no?
17.
78.
heard Mr. H. Betala, learned counsel for the petitioner. Also heard Mr. K. Mr. B. Sharma, learned additional public prosecutor, as well as Mr. M. Mia, A. Singh, appearing for respondent number 2. It appears learned additional public prosecutor submits that some more time may be granted to him for production of the case diary of Bokajan PS case number 78/2022. The prayer is allowed. Let this matter be listed on 27th of November. Yes.
As per office note dated 10/11/2025, no notice or copy has been returned back, my lord. But as per Dusty, my lord, it is already, the petitioner went to the house of the, my lord, respondent, but she refused to accept, my lord. Already
Affidavit has been
28/10/2025. It is also reflected in the office note also, my lord. Earlier also, my lord, one IA was filed. There also, my lord, she refused to accept the, my lord, Dusty service. Price, my lord, notice has been issued on her, my lord. Is 45, my lord, para 3, my lord, of the affidavit.
now, if the refusal by Dusty mode, where is the provision? Provision is there in CPC. We cannot apply CPC in CRPC in
Yes, sir.
criminal cases. What is to be done? When have you taken steps for issuance of notice through?
As per order dated, my lord, 18/9/2025, my lord, this honorable court has directed to take step on registered and
Registered post you have taken.
process.
So we will give a short date
Already, my
for,
lord, taken step, my lord, but no, till date, my lord. no.
we'll direct registry to place postal track consignment report on the next date.
But she has refused, my lord, already.
If she has refused, if it is found that she has refused,
It's the same thing, my lord, in IA also, the connected IO in this case, my lord. She refused to accept, my lord. In my lord, IA number 277 of 2025, my lord.
on next date, you let this court know that if in criminal case, the court has earlier issued notice to be served by Dusty mode, what is the fate, what consequence will follow if the service is refused by the addressee. In the meanwhile, we will call for the postal track consignment.
It returned back, my lord.
Okay, heard Miss N.S. Thakuria, learned counsel for the petitioner. On perusal of the office, note, on perusal, learned counsel for the petitioner has submitted that the petitioner was directed to serve the notice on the sole respondent by way of Dasti mode. And accordingly, the petitioner approached the respondent for effecting the service. However, the notice was not accepted by the respondent, and it was refused. I have gone through the affidavit submitted by the petitioner. Since in this case, order is of which court?
My lord, from the principal just family court.
Since the petitioner has, since it is found that the respondent has refused to accept the notice for abundant caution, refused to accept the notice issued to notice which was noticed by Dasti mode, continue. Hence, for abundant caution, this court intends to go through the track consignment report of the notices issued to respondent. So, by registered post with AD. And therefore, the registry is directed to place track consignment report of the notice issued to respondent number, sole respondent by registered post with AD, comma, on the next date fixed. Let this case be listed again on Thursday, 20 November. 20 November.
Yeah, but it's a criminal appeal against the accused. Lawsuit will find judgment at page 13. And 15 is the lawsuit will find page.
You are
15.
victim.
No, I am the complainant. It's a complaint case, but the London trial court has acquitted the accused on the ground that there is no offense of personal manner. But as per the evidence and witnesses of PW 2 and 3, that the independent witness matter. It is specifically found that there is specific accusation against the respondent, the accused, which was not properly appreciated by the London trial court. And trial court has simply go by the evidence on the ground that there is a principal, and the complainant was the office assistant of that school manager. And only they have said that is official matter. But here it is specifically allegation is that the service record of the complainant was intentionally hide and purposefully not handed over to the next in charge headmaster. And that's why still he is suffering. And with criminal intention, and charge was framed under section 409, 166, 427 IPC. And so there is enough ground for interference, this, that judgment of the trial court.
But this is a appeal against acquittal.
Acquittal lordship.
You have to obtain leave.
Leave has been granted.
Leave has been granted.
Question, I was disposed of, leave has been granted.
Okay.
So my prayer is the lordship may admit the matter and call for the records.
Where is the ISO? Heard Mr. R. Saha, learned counsel for the, sorry. Heard Mr. S. Nath, learned counsel for the appellant. Also heard Mr. State is a party.
No, it is a private.
Stop. This appeal under section 419 within bracket 2 of the BNSS has been filed by the present appellant impugning the judgment and order dated 25/6/2025 passed by learned Chief Judicial Magistrate Sri Brumi in CR case number 620/2017, whereby the respondent number 1 was acquitted in the said case. Learned counsel for the petitioner has submitted that by order dated 3/9/2025, a coordinate bench of this court has already granted leave and 3/9/2025 passed in criminal leave petition 42/2025 had granted the leave to appeal to the present appellant. Stop. This appeal is accordingly admitted. Issue notice to respondent number 1. The the appellant shall take steps for issuance of notice by speed post as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. The registry to take steps for stop. In line to continue. Let the records of CR case number 620/2017 be called for from the trial court. The registry to take steps for requisitioning the trial court record. List accordingly.
Pleasure.
May I please, Lordship? In this case, my lord, earlier, my lord, 7,000 and subsequently respondent filed petition, my lord. On the basis of that petition, my lord, and learned trial court allowed 24,000 per month, my lord, maintenance.
Maintenance.
Yes, my lord, 24,000 allowed. And in this case, my lord, petitioner received gross amount salary 54,994, my lord, case 48. my lord.
Lord, I have prepared for the sole respondent, Lordship. Matter will be taken up for final disposal subject to arrival of the records.
Records would be necessary.
Lordship, I have an option for final disposal.
Records would be necessary.
Yes.
We'll admit this
My lord, on last, my lord, 17.
and call for the records of the.
Will take up short date may be given, Lordship. I have no objection on that. Go for
Heard
final.
Mr. A.M. Ahmed.
My lord, before passing order, my lord, as per Supreme Court order, my lord, Supreme Court judgment, my lord, 25% of the net salary would be adjusted for maintenance, my lord. I am on that, my lord. Petitioner receiving salary 54,900, my lord.
And in this case, my lord, 24.
Your husband
Yes, my lord.
will decide this contention finally.
Finally, my lord, in the meantime, petition may be allowed to 15,000 per month.
No, Lord.
24,000 is,
How much you are paying?
my lord, 24,000 allowing me.
That
Lord,
judgment,
court-
what is referring lordship, subject to all kind of further hearing,
Let
only
me
for
see,
wife,
Let me see.
only for wife. So they may not be-
Okay.
My lord, 7,000, initially 7,000, my lord. Jumping the 24,000, my lord. And your salary is to 54,000.
Because I have-
20% would
They
be
have
adjustment.
annexed the
of
affidavit
Let
also.
me see, let me see.
No, we'll decide. What is your age? What you do?
My lord, I may be allowed to 15,000 per month.
No, what do you do?
A constable.
No, no interim relief at this stage. We'll fix a short date for final.
I kindly see 48 page, my lord. And your salary 54,994.
No, we'll examine your contentions,
This is the.
but you will not die if you pay 15,000 to
They
your
have not given the affidavit as per this Rajneesh versus Neha lordship, which should have been there. That they
hard
have got
Mr.
other incomes
A.M.
also.
Ahmed. But she may die if she does not get. A.M. Ahmed or A. Ahmed.
Yeah, ma'am.
A. Ahmed. A.M. Ahmed, learned counsel for the petitioner. Also Mr. S.K. Poddar, learned counsel for the sole respondent. Stop. It appears that records of the trial court would be necessary for consideration of the order was passed in a 127 application.
127.
Records of the trial court would be necessary for consideration of the instant revision petition. Hence, let the records of FC criminal miss case number 571/2022 be called for from the Court of Learned, Principal Judge, Family Court, Borpeta. Stop. This revision petition is admitted for hearing. Endeavor shall be made to finally hear the matter and dispose it of on the next date fixed. Let this matter be listed on 4th of December.
Obliged.
May it please your lordship. Lordship, respondent number two has appeared by law today.
This is. Oh, yes.
May I release your lordship? Lordship, I am representing the respondent number 2, my lordship. This honorable court passed an order 06/04/2025. Behind my back, my lordship. Lordship, with profound respect, my lordship, this honorable court leaves a question. Does the living relationship partner can claim maintenance? That is the question, substantive question of law, my lordship. So, my lordship, my first humble submission.
No, we are ready. Both are ready for hearing.
Lordship, date may be fixed, my lord, because they have filed the affidavit, my lord, of course. And they have appeared today.
Why, on what ground you have filed this criminal petition?
Yes, my lord. First of all, my lord, lordship may kindly see,
Live-in relationship.
yes, but this is of course not valid. Lordship may kindly see page number 12. It is a complaint filed by the respondent number 2 before the family court, my lord, seeking maintenance, my lord. Seeking maintenance.
Page number?
Page number 12. It is the petition filed by the respondent number 2. Before the
Yes.
learned family court matter.
Yes.
May I read, my lord?
No, what do you want to show?
Lordship, basically, the thing is that the respondent number 2, Lordship may kindly, I would like to point out paragraph number 2 first of all. Paragraph number 2, because my name is Abhijit Ghosh. Abhijit Ghosh. And that respondent number 2, my lord, Lordship may find at page number 2. I mean, para number 2,
Yes.
that a male child already born to her out of some relation between one Mr. Sunny Go. Then thereafter, my lord, the maintenance case has been filed against me.
Why?
Lordship, may I respond that?
No, then what is the
Then, my
allegation
lord,
against you?
Then, my lord, respond number, then, my lord, paragraph number 4, my lord, that is against me, my lord. That the petitioner begs to state that on 15/11/23,
So she cohabited with you later on.
that is the averment in the complaint, my lord. But this is not the fact, my lord. My lord, the
No,
lord,
fact will be decided by the trial court.
my lord, the prima facie, my lord, the petition, my lord, does not disclose the place of cohabitation, my lord. And moreover, my lord, the affidavit filed by them, because the lordship knows that shared household has to be there for basic parameter of living relation is that shared household, my lord, and domestic relation, my lord, between the partners, my lord. Now, lordship may kindly see the affidavit filed by them. There are some text messages at page 27 onwards, my lord.
No, on what ground you have filed the criminal petition?
My ground is that this is not a living relation in the nature of marriage, my lord. You only live in relation in the nature of marriage, one can claim maintenance from the other party, partner, my lord.
But that plea you can take before the trial court. That plea that it is not living relationship in the nature of marriage.
My
Whether this court will sit as trial court.
No, my lord, but I have approached, my lord, because on the face of the record, my lord, the complaint petition does not disclose that they are in a live-in relation in the nature of marriage, my lord. And lordship may kindly see for a moment, my lord, page number 28 onwards. There are some text messages through mobile, my lord, Instagram. That itself proves that they are not sharing a shared household, my lord. They are conversing only phone.
What is the requirement of a living relationship?
Yes, my lord.
Living,
Lordship, I would like to rely the judgment of the Velusamy, my lord.
where are the text messages?
Lordship, their affidavit, my lord.
Page number?
Affidavit filed by them. At page 27 onwards, my lord. Page 27. Of course, it appears that there is a love relation between the persons, my lord, but
What do you want to show by showing this?
my lord.
And they are not staying in a
Together.
same.
Of course, they are not staying together. They are not having any shared household, my lord. This is one of the parameters, my lord, of living relation, my lord. But
No, you-
and the thing,
Suppose somebody takes to each other. Is it sufficient to come to a conclusion that they are not staying together?
that is why I am placing, my lord, that judgment, my lordship may kindly see there are 31 of the judgment, my lord.
Velusamy.
Yes.
Velusamy.
Last page. my lord. There are 31. In our opinion, relationship in the nature of marriage is akin to a common law marriage. Common law marriages require that although not being formally married, the couple must hold themselves out to society as being akin to spouses. They must be of legal age to marry. They must be otherwise qualified to enter into a legal marriage, including being unmarried. But she is married, my lord. They must have voluntarily cohabited and held themselves out of the world as being akin to spouses for a significant period of time. Next, my lord, in our opinion, a relationship in the nature of marriage under the 2005 Act, Domestic Violence Act, my lord, must also fulfill the above requirements. And in addition, the parties must have lived together in a shared household as defined in Section 2S of the Act. Merely spending weekends together or a night stand would not make it a domestic relationship. Because they must have a shared household value. And their affidavits is showing that.
This proceeding is under 125.
Yes. 144 now under BNS. Lordship, again, Lordship, I would like to point out that in this case, my lord, in the judgment, another judgment has been referred to. Lordship may kindly see para 11. This is, my lord, in Bimala versus Biraswamy. Who can claim maintenance under Section 125, my lord? That is there, my lord. The definition of wife is also there.
Yes, read.
In Bimala versus Biraswamy, the three-judge bench of this court held that Section 125 of the Code of 1973 is meant to achieve a social purpose, and the object is to prevent vagrancy and destitution. Explaining the meaning of the word wife, the court held within quote, the object is to prevent vagrancy and destitution. It provides a speedy remedy for the supply of food, clothing, and shelter to the deserted wife. When an attempt is made by the husband to negate the claim of the neglected wife, depicting her as a kept mistress on the specious plea that he was already married, the court would insist on strict proof of earlier marriage. The term wife in Section 125 of the Code of Criminal Procedure includes a woman who has been divorced by a husband or who has been obtained a divorce from her husband and has not remarried. The woman not having a legal status of a married wife is thus brought within the inclusive definition of the term wife, consistent with the objective. However, under a law, a second wife whose marriage is void on account of the survival of the first marriage is not a legally wedded wife and is therefore not entitled to maintenance under this provision. Facts are very clear, my lord, in this case, my lord. She should have, my lord, claimed the maintenance from that Mr. Sony Group, my lord. And to them,
No, to him also she was not married.
of course, my lord, but she was having a child with him, my lord. He's having a child. The basic thing is that, my lord, the affidavit filed by them only shows that they're in a distant relationship. Of course, there might be some love relationship, my lord, but living relationship is not there in the nature of marriage, my lord. The text showing that, my lord. Shared household is a basic parameter, my lord.
Lordship, may I make my submission? My Lordship, my first objection regarding my learned friend saying that she should have claimed maintenance from the first. As per the Section 125 CRPC and 144 of BNSS, my Lordship, only she could have claimed maintenance from the first husband or boyfriend, whatever it might be, if she could not have second relationship. If he entered in the second relationship, cohabited the second guy, how could seek again claim maintenance from the past. That is impermissible under law, my lordship. And second thing, my lordship, with due respect to my learned friend said that in the text message and in the photograph, it shows that there's distance couple, my lordship. Lordship, my respectful submission before your lordship is this. Just because of they have related some text shortly messages, that cannot be a tantamount, they are in distant relationship. And second thing before your lordship is the photograph itself shows they are together. And in their petition, my lordship, with due respect to my learned friend, they have stated in their petition that there are no tasks about. They are not even, it is seems like that they no one does not know on another. But in my petition, my lordship, where I have demonstrated, they have photos together, they have text message together, which basically confirm, my lordship, that yes, and either it is in the nature of relationship can be tantamount to be live-in relationship. That part I will leave at your lordship should be decided by the trial court at the first instance, my lordship. And second thing before your lordship is that my learned friend relied to judgment. I would like to relate 3 more judgment of the Honorable Supreme Court. This cannot be a blanket ban, my lordship. It must be decided particular facts and circumstances where the Honorable Trial Court will look into the facts, evidence, and all this together. If all this putting together can reliable, then they can be decided the maintenance and the live-in relationship are not. But under section 125.
What is the corresponding provision of section 125 in BNSS?
On 44 BNSS, my lordship. Lordship, may I make 3 more?
Yes, just a minute.
My learned here in this proceeding, my lordship, criminal quashing petition, though I am going to rely on Honorable Supreme Court judgment, when Honorable this court can quash a petition. Before that, my lordship, I would like to point out 2 more things, my lordship. Lordship, here my learned friend burden is more than me, because here he come to quash the entire criminal proceeding before the family court, my lordship. My burden on me before your lordship is this one: show a prima facie relationship them, and their job is to either their statement must be.
What is live-in relationship?
Live-in relationship, basically relationship if the man and woman are lived under the same household together, they have mutually lived together without any force and coercion in the same household, and that must be in this, they understand it, not that they have to live together all the time. They might go somewhere else for work, then again come together, then again go. It is just like family, husband and wife, they live. Suppose, my lordship, I'm giving an example.
Any authority is there where it has been?
Yes, my lordship.
As to what is living
Yes, my
in
lordship.
relation?
Yes, my lordship. There are observations on our Supreme Court. I am placing a judgment before your lordship. Kindly look into my lordship, my judgment. This is not lordship, exhaustive part, my lordship.
Which judgment?
Lordship. Okay. My lordship, Indra Sharma versus BKB Sharma, 2023. Lordship, kindly look into the paragraph 52, my lordship. Here from 55, my lordship, I have annexed it.
No, just a minute. Have you provided that?
Yes, judgment I have provided.
Pradeep Kumar?
Paragraph 55, my lordship.
Yes,
Lordship, may I read, my lordship?
para 55.
Yes, my lordship.
Yes.
We may, on the basis of above discussion, call out some guideline for testing under what circumstances a living relationship will fall within the expression relationship in the nature of marriage under section 2 close bracket F of the Domestic Violence Act, my lordship. The guideline, of course, are not exhaustive. That means it cannot be exhaustive. There might be more ground that can be included under facts and circumstances will be decided, my lordship. But will definitely give some insight of such relationship. Duration of period relationship section 2 close bracket of the Domestic Violence Act has used the expression at any point of time, which means a reasonable period of time to maintain and continue a relationship which may vary from case to case, depending upon the facts and situation, my lordship. Second, my lordship, shared household. The expression has been defined under section 2 clause located S of the Domestic Violence Act and hence need no further elaboration. Third, my lordship, pooling and of resources and financial arrangement of supporting each other or any one of them financially sharing bank account, acquiring immovable properties in joint name or in the name of women, long-term investment in businesses, shares in separate and joint name, so as to have a long-standing relationship or maybe guiding factor. Domestic arrangement entrusting the responsibility, especially on the woman, to run the home, do the household activities like cleaning, cooking, maintaining, or upkeeping the house, etc. In an indication of a relationship in the nature of marriage. Sexual relationship, marriage-like relationship refers to sexual relationship, not just for pleasure, but for emotional and intimate relationship, for procreation of children, so as to give emotional support, companionship, and also material affection, caring, etc. Children of having children is a strong indication of a relationship in the nature of marriage. Parties therefore intend to have a long-standing relationship. Sharing the responsibility for bringing up, supporting them is also a strong indication. Socialization in public, holding out to the public and socializing with friends, relation, and others. If their husband and wife is strong circumstances to hold the relationship is in the nature of marriage. A intention and conduct of the parties, common intention of parties as to what their relationship is to be banned, be and involved, as their respective roles and responsibilities primarily determine the nature of relationship. May I please your lordship one more fact, my lordship? Lordship, these are not all need not to be affirmative. It might be 3 conditions satisfied or 4 conditions satisfied. Honorable trial court will decide, seeing the facts and circumstances each and particular case, my lordship. My humble submission before your lordship may only interfere if it is substantive question of law, my lordship. At this present case, my lordship, just has been FC criminal case registered before the family court, my lordship. Let whatever the plea my learned friend wants to make, let him make his plea before the land trial court. If the trial court found out all the facts are wrong, all the facts are not sterling, honorable trial court will decide the matter, my lordship. That is my submission, my lordship. In fact, I'm going to rely one more, two more judgment if the time permits, my lordship.
On what point?
My lordship, in fact, my learned friend quashing the petition under 528 itself is not sustainable under law, my lordship. I'm going to rely on the judgment of Supreme Court, my lordship.
Which case?
My lordship, I have submitted for Lord Pradeep Kumar Keshwarani versus State of Assam, Uttar Pradesh, State of Uttar Pradesh, and others respond in my lordship. I would like to point out few things before your lordship. When Honorable High Court will decide to quash a criminal proceeding, my lordship, ordinarily it must not be exhaustive. Ultimately, Honorable Court will decide, but there are some guidelines given, my lordship. Para, my lordship. Para 20, I think, my lordship. 20 of my lordship. May I read, my lord? Page number 13, my lordship.
Yes.
Lordship. The following steps should ordinarily determine the veracity of a prayer for quashing raised by an accused by invoking the power vested in the High Court under Section 482 CRPC, which is squarely will be applicable to 528 of BNSS, my lordship. Step 1. Whether the material relied upon by the accused is sound, reasonable, and indoubtable. That means the material is of sterling and impeccable quality. Second, step 2. Whether the material relied upon by the accused would rule out the assertion contained in the charges leveled against the accused. That means the material is sufficient to reject and overrule the factual assertion contained in the complaint. That means the material is such as would persuade a reasonable person to dismiss and condemn the factual basis of the accusations as false. Third, my lordship. Step 3. Whether the material relied upon by the accused has not been refuted by the prosecution/complainant and or the material is such that it cannot be justifiably refuted by prosecution/complainant. Fourth, my lordship. Step 4. Whether proceeding with the trial would result in the abuse or process of court would serve the end of justice. If, my lord, this is very important, my lordship, if the answer to all the steps is in affirmative, that means, my lordship, all the 1, 2, 3, 4 must be in the affirmative. That all must be fulfilled. Then can be Honorable High Court will be quash this proceeding. Judicial conscience of the High Court should persuade it to quash such criminal proceeding. In exercise of power vested in it under Section 42 CRPC, such exercise of power, besides doing justice to the accused, would save precious court of time, which would otherwise is wasted in holding such trial as well as the proceeding arising thereof, especially when it is clear that the sham would not conclude the conviction of the accused. So basically, my lordship, Honorable Supreme Court says that even my friend shows the impeccable sterling that nothing has ever shown. Here I have photographs from textbooks. So I think, my lordship, with profound respect, that I made out a prima facie case, my lordship. Yes, the relationship, either it was a live-in relationship or not live-in relationship, reasonable time to test it together or not, either they have cohabited together or not, my lordship, either they have bank account either together or not, either same household live together or not, everything, my lordship, will be facts, my lordship. All these facts, my lordship, should and must be decided by honorable trial court, my lordship.
Anything?
Basically, I'm on the point, my lord, the domestic relation, my lord, and the shared household. The complaint does not reflect that basic parameter, my lord, the domestic
But
relation.
shared household is relevant if we are dealing with a proceeding under DV Act. In this, the proceeding is under
No, but that will come into play, my lord, because, my lord,
Because relief of
this
shares-
concept, my lord, now this is the new concept, my lord, live-in relationship, my lord. So that is why, my lord, that will be applicable, my lord, because that the judgment I have relied upon, my lord, that is reflected.
that judgment is also in respect of a case under domestic.
125.
125.
125.
Lordship, may I make a final submission, my lordship?
No,
Lordship.
no. Which point do you want to say?
Lordship, I would like to point out this concept of live-in relationship in my respectful submission before your lordship, that it must not be interpreted literally, my lordship. Time and attitude have been changing, my lordship. And so our constitution is a dynamic and changing constitution, my lordship. So this is an evolving jurisprudence, my lordship. And it is an evolutionary and teleological concept, my lordship. It must serve the time, my lordship. So that is, my lordship, I would like to point out.
Yes, heard Mr. T. Kolita, learned counsel for the petitioner. Also heard Mr.
R. Amin.
Amin,
my lordship.
R. Amin, learned counsel for the respondent. State is also made party. Why? State is not before the trial court.
Well, this is a criminal petition that we have to make them party, my lord.
Also heard Mr. K. Bosho, learned additional public prosecutor. Hearing concluded, judgment reserved. I am reserving the judgment.
Typical plus, my lordship.
The time being matter, my lord, I just, my lord, apology, my lord, because I have to rush to another, my lord, coordinate.
Time being.
Not time being, my lord, that matter, my lord. My lord, I have gone through that, my lord, but my lord, regarding the CD entry, that is not available. What is available is only, my lord, the 47 and 48 notice, where, my lord, categorically those sentences are there, my lord, that on the basis of that is the video footage. But, my lord, the CD entry is not available, not available with us, my lord. We have available only the statements which are recorded by the police that is available. In
CD has not been sent,
my
entire
lord,
CD.
not entire CD, my lord. If, my lord, call for that part, my lord, of the CD, my lord, because the entries are not available in all the 7 numbers of, my lord, that is files they have sent, but that I didn't get, my.
Actually, video clip is a documentary evidence. I think it's a bail matter is.
No, because co-accused prayer is rejected.
Right.
Therefore, we were inclined to grant you bail subject to condition that no material is against you. So
Other
we have to
material.
verify.
On that, on those things, my lord, there is the CD, my lord, there is the entry and all this, maybe.
Heard. How to get that? Heard Mr. K. R. Bora, learned counsel for the petitioner. Also heard Mr. K. Bosho, learned additional public prosecutor, who submits that he has gone through the case diary. However, he could not find the relevant pages in the case diary where mention about finding the presence of present petitioner is there in the CCTV footage. However, he submits that in the notice issued to the present petitioner under section 47 of the BNSS, it has been clearly stated that one of the main ground for apprehending him in the instant case is that his presence could be identified. His role in the alleged offense could be found on perusing the case CCTV footage. CCTV footage. Stop. As such, the perusal of the entire case diary would be necessary. Hence, the trial court is directed to send the scanned copy of the entire case diary to this court so as to reach this court on or before. When? Where is the court? Jorhat?
My lord, Jorhat, Lordship.
On or before 28th. On or before 25th of November.
There, my lord, the word uses, my lord, only video test, my lord. Not exactly CCTV.
No, CCTV cut it out. Video footage. Video footage instead of CCTV.
Lordship, I take Lordship permission, Lordship. Item number 7, Lordship has already passed the order, Lordship. Here, Lordship has allowed me to file an additional affidavit. Lordship, that technical issue has arisen. The petitioner works for a US company. He left for US yesterday, Lordship. And he'll take little time to come back. I may be allowed on his behalf because there's nothing changed in the anything. Only I have to annex one paper which I missed. There was 2 sheets of paper, I annexed one. That everything is put in the paragraph.
No, anybody who is acquainted with the facts of the case may file affidavit.
Because this is.
No, therefore, if you are acquainted, you can
Yes,
file.
yes.
But that I will not reflect in the order.
But
If-
it is convenient for, it will be convenient for me if it is reflected, Lordship. Because I have got that, it will be by prior permission from the court also.
Okay.
That will be helping.
Item numbers 7 or that are line 8 করে দিব. Learned counsel for the petitioner has submitted that since the petitioner has left for United States of America, he may not be able to swear the affidavit, additional affidavit. Hence, since she is fully acquainted with, since as a engaged counsel, she is fully acquainted with the facts of the case, she may be allowed to submit the affidavit on behalf of the petitioner, the additional affidavit on behalf of the petitioner. Prayer is allowed.
Highly obliged, Lordship.
Lord, as regard item number 55, my lord. Later, my lord, quashing away, my lord, criminal proceeding.
No, what is
Because
the plan?
Informant is also present. It has already, my lord, see, he has filed in Bhakalatamam. No, it's affidavit.
No, what do you want now?
Because 15th is the date, my lord, fixed. Day before yesterday also I mentioned, my lord. That is why it was fixed today,
Tomorrow we'll take it up at 2.
my lord.
At 2.
I'm obliged, I'm obliged.
Raise this matter tomorrow at 2 p.m.
Obliged.
Lordship, with regard to item number 24, my lord, last occasion scan copies were called for, probably that is not on record. A reminder may be given by the clerk, and a date may be. That is my minimum prayer.
Okay, item number 24.
24.
You are appearing.
Yes, sir.
Item number 20.
And
Case records who call for your Lordship.
Record the name of the counsels. Let a reminder be issued for scanned copy of the trial court record. Release this matter again on 27th of November.
highly obliged. Keep that.